Everybody, y'all can be seated. All right, I know that some motions in limine just got filed. I haven't even had a chance to look at what those might be yet. Has the state seen them?
No, Your Honor.
Okay, well,
I'm pulling it up now.
huh. Is Mr. Sprinkle available right now?
We can find out.
Have him come over here.
Your Honor,
Mm-hmm.
can I briefly address something before?
Yeah.
Good morning, Your Honor.
Good morning.
I appreciate you forwarding to us the ex parte communications you received from Madam DA Fonnie Willis.
Mm-hmm.
Given the sensitivity and the history in this case of ex parte meetings or maybe communications, would you just please request the state? I understand probably what was behind that communications. And of course, it is great for a boss to buck up an underling who has perhaps been attacked or maligned. But I don't believe that, and I don't think the court does either, that the court should have been copied on that communications, especially one that reads maybe more like a campaign ad with a search story in it than anyway, I just don't believe it was appropriate. And I would just ask you to please ask the state to halt any future communications ex parte they might want to have with this court. That's all I have to say. Thank you, Your Honor.
Yeah, it's a shame that the court would even have to say something like that. But can you all please communicate to everybody in the DA's office to not have any sort of ex parte communications with the court? And y'all may not even know what I'm talking about because I don't think either of you was copied on that email. But Ms. Love was. Ms. Hilton, you were as well?
I do, Your Honor, and I don't know, I know exactly what you're talking about. I think we have a different perception of it, direct communication with the court, but we will
But the
make
court
sure
was
that.
copied on it. And it could have been an accident, but
And Your Honor,
it should have been careful.
but the state did not have the initial conversation with the court. That was
No, I
a
know
community member, and it was very much a reply. Also, was not a direct communication with the court, but we understand the court's perspective. We understand what the court is saying.
Oh, excuse me. I just need to take issue with the fact that it wasn't a direct communication from the court. I'm sorry. Excuse me. Can you hear me now? I didn't mean to act like Max Sharp. I take issue with any type of suggestion that this was not a direct communication with the court. It went from Madam DA Fonnie Willis to this court. It was a direct communication to this court. It was inappropriate. It was praising Georgia's RICO statutes to the court, which again was not appropriate, Your Honor.
Frankly, I think it might be a good idea to print out the email and make it a court's exhibit to this record. But I think what Ms. Hilton was just saying was that the original communication was not from the district attorney's office. The original communication was, I don't know who this person is or where in the world they are, but some member of the world, member of the public, emailing Miss Love directly, but copying several other people, the court included, because of course our email addresses are a matter of public record. And, you know, I basically ignored it and deleted it. But as you all know, because I forwarded the next communication to everybody, the elected DA, Ms. Willis, made a decision to respond and directed that response to Ms. Love, but kept everybody, including the person who had made the original email communication, and the court on her response to Ms. Love. And I believe that to be ex parte, and that is the reason why, as soon as I read it, I had Ms. Persifield forward it to all counsel, because I don't think that should be going on.
And I certainly appreciated that, Your Honor.
And
Thank
the
you.
court really has ignored entirely the substance of the communication, because the court is not making any decisions based on whether I think the RICO statute is good or bad. That's not what judges do. The legislature enacts statutes. I apply them hopefully correctly.
And I have no
or
concern.
whether anybody thinks any attorney is doing a good or a bad job. I'm just sitting here trying to follow the law.
Yeah, and I'm not concerned about any impact on the court from that communication.
Yeah.
It's just the
Shouldn't be
communication
happening.
itself. Thank
Yeah.
you.
So, Ms. Persifield, if you don't mind printing that out, and I have no idea what court exhibit number we're on, but if somebody can figure that out, we'll number it, court's exhibit number, whatever the next one is. Do you know?
Your Honor, our numbering system is broken down by act, which is why we have the different letters. So
Oh, no,
talking
court
about the
court
court's
exhibits.
I will check that, Your Honor.
We don't know, Your Honor.
I mean, I don't know either, but somebody does. The court reporter, or the last court reporter, maybe. But anyway, we'll get that figured out and make that a court's exhibit. Okay. Mhm.
Mr. Sprinkle is on his way.
Okay, thank you. So I can't imagine that I am going to grant motion in limine number. Is it numbered? This one's not numbered. But the motion that requests work product of the defense of the prosecution, but I haven't gotten through the entirety of it yet. Nor, I suppose, has the district attorney. And they would be entitled to respond, but that just doesn't seem like an appropriate thing to do. I'm going to give them a chance to take a look at it and digest it and respond. All right, I think probably on all of motion number 65, I'm apparently looking at them out of order, but, and number 64, we're going to give, we might be able to take them up this afternoon, but I'm going to give the prosecution at least through the lunch hour to respond to those. So we'll address those after lunch. Okay.
Your Honor,
Yes.
I will say that I know this morning we're going to be discussing some of the Instagram content of Mr. Ryan. And I think the argument which comes up in number 64 is also going to be relevant during those discussions.
Okay, I didn't even look at 64 very carefully, honestly. Thought I would look at it at lunch as well. So let me take,
Now, I certainly will take a look at it too, because I always appreciate Mr. Steele bringing me the law I need.
okay, well, let's turn for now to the issues that we're going to tackle about the evidence surrounding Mr. Ryan. Let me find my notebook. All right. Did the state get a chance to look at the law sent over about the in-life photograph and what y'all's position on introducing that photograph through the mother?
Yes, Your Honor. We'll meet with Ms. Holmes again, but I don't. Good morning. We'll meet with Ms. Holmes again. In our previous meetings with her, she has not been overly emotional about this case with involving her son. Her being on stand will be very limited to getting in the photo, and then she will be completed with her testimony. And so we believe, just given the witnesses that we have, that she would be the best witness to enter into that photograph. Miss Smith is the individual we believe assisting in setting up this homicide. Mr. Uten and Mr. Mitchell, at this juncture, in all honesty, are not very cooperative. And so those individuals to bring in this picture of Mr. Holmes, we believe would be inappropriate. The mother can do it.
Honestly, I can't hear that one either.
The mother can bring in this photograph. She will be up here for a very limited purpose, and we believe that it would not violate Good or any other of the other.
That mic is not working. You have to hold it closer to your mouth.
Okay.
So you believe that whichever one of those witnesses that was in the car, if you said, is this whatever the person's name is, they would say, I have no idea?
It's very possible, Your Honor. At this juncture, all of our witnesses who come in here should be able to answer simple questions. Unfortunately, do not. I mean, we've seen it time and time again, simple questions.
Okay, you know what? How about try it with one of them? And if they refuse to identify the photo, then call the mom. Okay?
Yes, Your Honor.
All right.
And then, Your Honor, also for the in-life photo, Mariah Smith, who's going to be a witness, they're going to show her a photo that she posted on her Instagram anyway. So having two photos of Mr. Holmes would be cumulative.
Your Honor, we will. We will follow the court's instruction. We will try to get it in through one of the other witnesses.
Okay. All right. And then, I mean, if it's already, it's the same, it's not the same photo, is it?
No, Your Honor.
Is there going to be some other purpose for the Instagram photo with, what page number are these people on? Do y'all know? Okay. Okay, Miss Smith, the Instagram photo of Mr. Holmes, you'd be using it.
If we choose to, that's one of the pictures that we placed in the items to discuss.
Okay,
So we are deciding, as we would with any witness, what evidence we're going to admit. So we may or may not admit that Instagram.
okay, well, if there would be no other purpose for it, then it would be cumulative. There may be some other purpose they might have.
Your Honor, I expect that photo to come in through Ms. Smith. She testified at the original trial. When she spoke to officers, she said she spoke to the victim every day at trial. She said she'd never met him before that night. And of course, she's posted a photo of him on Instagram. So we certainly anticipate bringing it in to impeach her from her trial testimony that she didn't know him.
All right, but I mean, that would be after you'd be cross-examining. So I would imagine if they ask the same question, they could do the same thing.
Sure.
All right. Yes,
Good morning.
good morning.
Good morning, Chair. Your Honor, in this case, you reference, which is Gude, Gude versus State 313 Georgia, 859. It's in Division 2B, as in Barry, it's 2022 case. And I've litigated this, and I know the court said it yesterday. In a murder case, God forbid, the in-life photograph is relevant because you have to show that the person was alive, and then is the corpus delicti is no longer living. But this is a conspiracy RICO count. So the overt acts don't, and that's going to be another issue that we argue before your honorable court, whenever you call it. But those overt acts don't have to be proven. It just has to be contemplated that overt act has been commenced in some way. It could be a lawful act. But here, the state is putting in, or wants to put in through a parent, the loss of a child. That's just unbearable. And whether they're going to cry or show their emotions or not, I'm not so sure that it has much relevance. I don't think under the paragraph 2B of the Gude case, the Supreme Court specifically talks about that, it may not even be relevant, and then it would be a waste of time, and it would be prejudicial, especially if another photograph is coming in. So I just want it to be waged that that's the objection. And we're going to have another killing in this case, and I know Mr. Williams is not involved in these, but it's wearing on a jury because those things go back to the jurors during deliberation. So I would like the court not to include an in-life photograph, except obviously Instagram or something like that if it's coming in anyway.
All
Thank you.
right, well, we'll see how it ends up coming in. Okay, let's, there's been an offer by the defense for Mr. Ryan to stipulate to the cause of Mr. Holmes, the manner of Mr. Holmes's death.
Yes, Your Honor. In discussing with defense counsel, we asked if they would be willing to stipulate to the autopsy report and the autopsy photos. They decided they do not want those, but only to the manner of death. While we understand that Mr. Holmes is only charged with the RICO count.
Mr. Ryan.
Excuse me, Mr. Ryan, I'm sorry, is only charged with the RICO count. And the murder is an overt act. We still have to show or prove the overt act for the jury to believe that it is a part of the conspiracy. And with Williams in her opening statement, didn't say these words exactly, but alluded to the fact that her client was innocent of the underlying murder, which was the overt act in this case. She thinks her words were similar to, he's here, he's been convicted, but that's because he didn't have a good defense, something to that effect. And that was stated in opening. So the state, we believe, still have to prove the underlying overt act, which is the homicide. Initially, the state was trying to avoid calling Dr. Sullivan and an ability to get in two, or I think we showed the court 3 pictures initially. Defense objected to the omission of those 3 pictures. And so the state at this time is prepared to call Dr. Sullivan for the limited purposes of talking about Mr. Holmes' injuries and admitting into evidence at least 3 photos. We don't intend to, honestly, we would ask the defense that they would stipulate that Dr. Sullivan is an expert, so we don't have to go through that line of questioning, but be able to prove our case, show that how he died, the manner of his death, and those 3 autopsy photos. We don't believe Dr. Sullivan's testimony would take longer than 10 to 15 minutes if we're able to get directly to the point of how he died, where his injuries were, and we will conclude our testimony at that point.
So what is the defense willing to stipulate to?
That his cause of death was a bullet to the brain, to the head. That's about it. And then the 2 victims that were also in the car, they could testify that they saw him in the car. They saw him, I guess, go over. Who else could testify? And then that's about it. I mean, I don't understand why they need the autopsy photos. So that's why I have the 401, 402, and 403 objection. They're only doing this to inflame the jury. There's no reason to bring in the autopsy photos.
Okay, well, they hardly picked photos that would inflame anybody.
Well, if seeing a 15-year-old on an autopsy table, which is what they did in their
Well,
opening,
you know
would
what?
inflame
He
the
got
jury.
killed.
He did, and they did a murder trial, and my client was wrongfully convicted.
Well, if you're making that argument, then they are entitled to prove it. So you will not stipulate to the medical examiner's expertise?
She was already admitted as an expert, so yes. I thought yeah, we'll stipulate to that.
Okay, great. All right, let me see the photos again.
Yes, Your Honor. May I approach, Your Honor?
Yes. Thanks. All right, I'm going to permit them. Thank you. All right, did y'all give me a sheet of paper that had what y'all had agreed to and what we still needed to litigate on Ryan or not? I mean, it would have been an email, but
We did not, Your Honor, because we have been going back and forth. We can,
Okay.
when we get to those pictures, we can let you know what we've agreed to, Your Honor.
Okay, so what would the best thing to do be pull up the Dropbox link?
Yes, Your Honor.
Okay.
And Mr. Sprinkle is here, Your Honor, if you wanted to. He
Okay.
just walked in.
Hi. Going to do this right now, but when I read that, go ahead and sit down. You're sworn, you're already sworn, you've been a witness for days on it. You're still under oath, and I'm going to recall your attention to, I think it was the last day of, there was a laptop on the, accessed it,
Yes.
and you actually did that without anybody asking you to, or asking the court's permission. But can you tell me what all you looked at on the laptop?
Yeah, I had my supplement, that 140-page document, and I also had some of the stuff that I pulled during the case. Everything that's already been turned over in discovery, just in case I need to refresh my recollection. But primarily, it was just it was a digital version of the report that I had on the stand. That was it. So I could do word searches. So if I was asked a question, I wouldn't have to be flipping through pages and looking for things.
Okay. Was there any point in time when you accessed anything else other than that report and the files that in any way read any communication that came in at any time from anybody?
No, I wasn't communicating with anybody. I didn't have email open or anything like that. All I was looking at was the report and the digital media, like the discs that I brought to the stand with me, that stuff that was on the discs and the stuff that was turned over in discovery.
Okay. Back at some point with regard to this a motion that has just been filed after lunch. Are you going to be around this? And I don't know whether you'd be needed for that or not. Haven't read it in detail, nor do we have a response from the state yet. But would you be available this afternoon if we need you?
Well, I'm just one floor up, Your Honor, in courtroom 2B. I do have a couple of cases, but I mean, the short answer to your question is I will be in the building
Okay.
and the moment I can.
All right. Thank you.
Okay.
Okay. So let me get this Dropbox link open. Is it the same one from yesterday?
Yes, Your Honor. It's titled 9 October Centralized Motion Fold
On
1.
the email again. So.
And I can resend it.
Well, I'm sure Ms. Pursfield can probably do that fast. Yep. Oh, here it is. Where did it go? There it is. No, that's something else. No, I don't have it. No. All right, so if y'all, I've got it up now, so if y'all want to just let me know which ones we're going to need to take a look at.
Your Honor, I think we should start with, so there's a PDF titled 11 October. We have had a couple discussions and gone over what we're introducing and the various sides objections. And that 11 October Ryan IG thread is the most recent from Mr. Ryan's Instagram of the post we will be using that we would be discussing.
Okay. All right. All right, and what would the objection be? What's the objection?
Your Honor, I believe we're looking at page, excuse me, Instagram 125. We believe this is going to be cumulative of other posts and the testimony itself. This is a post attributed to Slim Life Shoddy, which is Lee planning to testify. I think he would be able to testify to exactly what's in these photographs without the necessity of offering Instagram photos.
Okay, so the one that is page 125, it's not a photo anyway, it's a post.
I'm sorry, kind of screenshot,
Okay,
image, whatever you'd like to
okay.
call it.
So, Your Honor, and if the court permit, may I remain seated?
Yeah,
Or-
that's fine.
Thank you, Your Honor. So the Slime Life Shorty Instagram handle is Wooney Lee, who is he will be a witness in this trial, was originally a defendant.
Mhm.
And this post is between Mr. Ryan and Mr. Lee. And he posts that he loves Mr. Ryan, he's realer than me. And then at the bottom, it says full throttle about you. The association between both of them, the state hasn't thus far in this trial with the jury, to my knowledge, introduced any evidence about Mr. Ryan and Mr. Wooney Lee's relationship. So this is the first photo we've addressed with the court explaining that. And the date it's posted is February 25th, 2019. The murder in this case is February 23rd, 2019. So the state feels it's relevant, and there's no other evidence introduced yet about this specific topic. So it's not cumulative in this moment.
Overruled. Ben, what's the next one? Are there other objections to other of the Instagram posts?
Judge, just on this, the relevance where I don't think we necessarily know who the other individuals in this photograph are.
Okay, are we moving on to, is this 127?
I'm sorry, Judge, yes.
Okay,
We accept your ruling of
okay.
overruled.
All right, yeah, no, I just didn't know if we were moving on to the next one or if we were skipping 3 because there was an objection, but,
No, I believe,
okay. And so the objection would be it's the other people aren't identified?
I don't know if they're relevant to this case at all.
Okay, what is so it's a relevance objection. What's the relevance?
Yes, and Your Honor, may I remain seated as well?
That's fine.
Your Honor, specifically 3 individuals in this picture are, we believe, YSL members. That would be @1Brees, which is Christian Eppinger, @real1_FR, which is Mr. Darius Ford, and Little Non-Life, which is Mr. Durante BB. We can block out the other individuals and only keep in the 3 that we know of are members of YSL.
Okay, when you say block out, you mean the tags. What about the picture itself?
When I say block out, the pictures of those other people and the tags of those other individuals.
All right,
That would cure the objection.
okay. All right, so then 128.
It's just the page reflecting the date that 127 was posted.
Oh, you're right. 129, sorry.
We have no objection to 129. Your Honor.
Okay,
And Judge, I will say, we object as far as these being prejudicial and cumulative. We have nothing further to argue as far as objections go. So when we say no objection, it's no further objection to the general objection for all of them.
Okay, so I mean, I'm not going to assume that each one of these has a relevance and cumulative objection, so I need y'all to state the objection for each of them, okay? So you think this is to be cumulative? What are your objections to 129?
We'll withdraw the,
Agree on that one.
we'll
We-
withdraw the objection.
Okay, so without
129?
objection. Okay, thank
We
you.
agree on that.
137. Any objection to 137?
No objection, Your Honor.
Thank you. Any objection to 143?
This is also a post with, this is Wani Lee, who's a co-defendant. And so at this point, this would be the second post cumulative.
Okay, what's the response?
Because in this post, it says slime is all we know. We can't go out bad, loyalty over love. So it's, again, it's showing, it's for one, using, he's referring to it as slime is all we know. And he's expressing loyalty amongst two fellow gang members, Your Honor, please.
Let me go back up and look at that first one. So are you saying when this references slime, what are you saying? I'm sorry, I don't
So-
really understand what your argument is.
When it says slime is all we know, we can't go out bad. There's been testimony earlier in Zachary's interview. He says a comment about catching someone down bad, which means to murder or hurt them. So when he says we can't go out bad, slime is all we know, we can't go out bad. It's like the gang is all we know. And it's saying loyalty over love right after that. So it's like, we got to protect one another. This is what we know.
So this is more than just the two of them's relationship. This is with regard to the larger gang.
Yes, Your Honor.
Okay, so the cumulative objection is overruled.
Judge, my question with this post and some of the others is going to be, I don't know if we're going to have a witness who's going to come in and say, this is what this person means. I don't think that would be appropriate. If I'd like to say this is author or whomever posted it. But the same question Your Honor has, looking at it, well, what is the relevance? I don't think it's appropriate for a witness to come in and say, this is what this person means when they posted this.
Are y'all planning to have somebody do that?
So two things, Your Honor. One, but specifically on that issue, the jury has heard from, the first witness was Detective Belknap, who is an Atlanta Police Department gang detective. So a lot of what I'm offering this to the court of why the state wants it, but
understand.
each individual post or comment is not going to, some of this evidence is already in evidence in terms of the state has had witnesses testify about gang identifiers, what these mean. So
Do you have somebody say, this is what whomever the poster was meant, because I'm in their head?
No, Your Honor. I'm not going to have someone get up and say exactly what Mr. Ryan meant when he posted this. No. Your
Okay,
Honor.
but y'all can certainly argue that if you want to, if and when we ever get to closing arguments. Okay. All right. Page 145. Any objection?
3, we'll take that as an objection overruled.
Yes.
Get any objection? 5.
All right. 164.
No objection.
Thank you. 166.
Yes. Subject to connection.
Judge, this is one that we had actually discussed with the state that we didn't feel it was relevant or appropriate unless one BS could be established who the person was. We were waiting on the state based on some evidence in the trial versus just, this is this person.
Your Honor, the state's understanding is that 1B Slime is an individual by the name of Jaborius Greer. Jaborius Greer, we believe, is the nephew of Mr. Williams. And we have had gang experts that have had interactions with Mr. Greer, and we believe he is also a member of YSL.
All right, is that going to come in evidence?
Yes, of who 1B Slime is, yes.
All right.
Because he's on a few other posts as well, Your Honor.
Okay. Through whom is that going to come into evidence?
I'm sorry, say that one more time.
Through whom?
Investigator Viverito.
Okay, and will that have been before or after this?
It'll be after.
All right, overruled. 203.
No objection.
211.
No objection.
236.
Objection or no?
All of us in the, I think we're trying to, I know this is kind of involving Mr. Ryan.
Well, I
But-
mean, the evidence is
Right.
coming into the trial, so.
I'm just trying to figure out, I'm in the Dropbox link that
Mhm.
Mr. Atkins sent, but you guys are, everyone's referring to as exhibit numbers, and I'm,
It's
No, no. So at the very top right, it says page 240, which I guess must be on the whole Instagram record. Just so it's what, 79 through 81, and then I think it's, at least for me, the second entry in there.
It's titled 11 October. Ryan IG thread.
All right, and then once you open it, you'll see the page number references, and that's what we're referring to right now. Sure. Okay, so we're on.
Yes, Judge, we are objecting to the relevance subject to some sort of foundation or connection about what this is about.
Okay.
Yes, Your Honor. Rudy, we believe 240, the post says Rudy 4L and the GVNG scene for take out the A and replace V. Rudy is a young man, and my apologies, his actual name is escaping me, but he was a member of a cell that was that is now deceased. And a number of YSL members either have Rudy 4L tattooed on them, or they have Rudy in some way. They honor this young man. And Detective Belknap has testified about Rudy and about this significance to YSL. And so the fact that Mr. Ryan is posting about him again shows his allegiance to YSL.
Okay. Well, given the testimony that's already come in, seems that's relevant. So overruled. 244.
Judge, we're just asking the ones who've not been identified or won't be identified be redacted out from this image.
All right.
So, Your Honor, because this post is titled Love All Mine and it has a snake emoji, the state, and it's a statement of party opponent, the state feels that all of these and some of these Instagram, in what we will get to in a little bit, interact with some of these handles. And so the state feels that it's relevant that in this public post, he says, love all my, the state interpreted as slimes, he puts the snake. And so the state feels that none of these should be redacted.
Okay, I see what you mean. Okay, that's fine. Then I will overrule the request for redaction. 258.
Judge, I feel this is highly prejudicial without any sort of connection to this actual case.
Response.
So, Your Honor, this is a 6 firearms, and the one on the far right has an extended magazine. So the state, we have whittled down pictures and reference.
Where does it come from? Like, what's this a picture from?
It's his Instagram, Your Honor.
Oh, right, okay.
And so, yes, Your Honor. So because at this point in time, we've tried, there's a number of pictures of firearms and pictures and videos. And so thus far, we've discussed one today. So the state feels that it's relevant to show access to firearms. It's his own Instagram that this is a photo he
Okay,
has. So the state feels at this point in time, it's not cumulative or irrelevant that there's 6 firearms, one at least visibly has an extended magazine in this photograph.
okay. Well, given that he's choosing to post this on his Instagram, I'm going to overrule the relevance objection. Page 260 is the next one.
No objection?
All right. 315.
No objection.
So then there's several pages of business records. That's just showing,
Your Honor,
what is that?
so this is Instagram. At the top of every page is going to have business record, but these are Instagram threads
Okay,
that the remainder of this PDF is various conversations
okay.
that Mr. Ryan is having.
All right, so Ms. Bossy, if you can direct me to whatever the next page is that you have objection to.
Your Honor, it's going to be the next few pages, which are number at the top is 400 through 404.
Okay,
I don't believe we have, or there will be any sort of identification about who the conversation is between besides Mr. Ryan and another person. Our understanding from the state is this is about selling firearms. And I don't know how that is relevant to this case about Mr. Ryan selling firearms.
all right, and I see that some of these things are highlighted.
Yes, Your Honor. So the highlights, it was to make it easier for both the court defense counsel to follow what the state feels is significant, because the way that Instagram returns come in, you can have multiple threads on different pages.
Okay.
And so it goes by time of when you get an incoming request. So it can get kind of confusing to follow, because it's not just a conversation between Mr. Ryan and one party. It's with her. So the highlights are, I may have missed a couple, but it's
That
to
particular-
orient. Your Honor.
All right, and so there's a relevance objection.
Yes, Your Honor. So this is in a similar category in regards to, there is a number of references to FYE when it says sell me a fire, the state, that is a gun, firearm. There's a number of these in the Instagram. The state wanted to include some of these so that these photographs of guns, it's him talking about actual firearms. Sometimes, and I'm not saying this argument has been made or will be made, but the jury, his discussions about real firearms, right? And so maybe they could be a prop, or maybe they could be, these photos we're showing, that this is just showing he has access to and is talking about.
Right, but we're not talking about the photo right now. It's as I understand the relevance objection, and it is, what is the relevance of him proposing engaging in conversation about a transaction to buy or trade firearms?
Yes, Your Honor. So in this case, in regards to count 1, it's maintaining armed individuals ready and willing to preserve, protect, and enhance the reputation through the use of violence. It also includes, ease and access to firearms. And so the fact that he is, casually discussing, because this specific one, Mr. Ryan is talking about, give me $250 for my Glock. And the party he's interacting with says, I got a Taurus, I'm going to sell it for $2. So it's simply to show the ease with firearms involving a case with a number of violent acts and his access to firearms. That's why the state wanted to include this. And I can see the courts, but that's able to
It's
include
not
this.
chagrin, but I doubt maybe as to the relevance of him wanting to sell a firearm, if that's what this is reflecting.
Yes, Your Honor.
Yeah, I'm going to grant the relevance objection. All right, what's the next?
I'm sorry, Judge, they've taken out a few photos or a few parts since the last time we
Okay,
discussed it.
that's- yeah.
Making sure I only talked about the ones which are relevant.
Appreciate it.
413. So I think we get up to 416. There are going to be a number of pages in here which it's just missing slat or just one phrase. And I guess our question is exactly how many of these do we need? Because we've got some images, we've got multiple conversations. How many times do we need to just see the same one word or same one phrase to establish that these are phrases or words that Mr. Ryan uses?
Okay, so I see the one that starts on 416.
Correct,
Is
Your
that a
Honor.
multi-page thing?
It
or-
is pages 416 and 417.
Okay.
And the state, again, has whittled down in the Instagram. There's a lot of reference
Okay.
to these terms, but the state wanted to include some because these are private, direct messages.
Okay, so this would be this 2-page
Correct, Your Honor.
correspondence.
And so it starts at the bottom of page 416 where instead of the S, it's the 5,
Right.
and it says slat, and it's between Mr. Ryan's Instagram is Slime Business Rod, and the person he's interacting with is Maniac with an X instead of the C, Rolac. And so that Instagram handle, I do not know exactly who Maniac Rolac is, but Pete Rolac, Sex Money Murder, founders of that street gang, that Instagram handle stands out. But nonetheless, it's just to show, and the state's not intending to do this 100 times. This is the first time we've discussed it where Mr. Ryan says slat with a 5 and the person responds, what's blazing twin? And then Mr. Ryan says he's basically just hanging out, but he's replacing certain letters like C's with B's. And then the other guy responds right side, and the right side is significant. And so this also has, so yes, Your Honor.
Okay, so that one's the first time we're seeing it, so that one can come in, and I don't know whether there are going to be more or not. My ruling might be different if there are more.
So Judge, from there, we move over to page 467, which is where we have a message between Winnie Lee, who was the speaker or the person in the first few photos the state wanted to show the association, with Mr. Ryan saying, "Very yacht slime, WYA, you good."
We're going to withdraw that, Your Honor.
All right, they're going to withdraw that.
All right. Judge, the next one is going to be moving up to page number 500.
And, okay, what's the objection?
So this 512 through 514 is a conversation, I guess, between _ free Juju, who I don't think we know who it is. It begins on page 512. 513 is a conversation where Mr. Free Juju says, the N-word you robbed named Booley. They're talking about some sort of conflict allegedly that Mr. Ryan had where he robbed somebody. we feel that's entirely too prejudicial to come in. And the conversation about it continues with Free Juju being the speaker.
So, Your Honor, this thread goes from Instagram pages 512 to 514.
Mhm.
And the state does not have, so just going to follow this thread because to orient for it. So it starts at the bottom of page 512 where Free Juju tells Mr. Ryan he's got to tell him about something that happened today. And
Right.
Mr. Ryan's like, well, what happened?
Right.
So the state has no problem previously robbed, but the state wants more so that he's talking about a specific person named Bully. And then Mr. Ryan's like, yeah, I remember the guy robbed. And then they go further. And so what this is, Tobias had got caught for an X, which the state believes is a gun, while he was walking on the back street back from school.
Right.
And then, long story short, this individual draws down on him and brandishes a firearm at him, and he's telling Tobias was scared. And so, in response to that, and Mr. Ryan says, "Were y'all striking on Cleveland? Striking typically can be going in to break into cars and steal items." And he's like, "No, we weren't breaking into cars. We were walking to school smoking, and we
Right.
saw a gun on the seat." And then further on, what Mr. Ryan responds to that in terms of the person letting someone draw a gun on him and not resort to violence back is, "Y'all are reckless. Why did y'all let Bully draw down on him? Now y'all can't get bust down. I'm going to draw on him on slime." So it's the state kind of wants these 3 pages for that last line where he says, "I'm going to draw down on him on slime,
Okay.
on the gang."
All right, so just redact on the thread, I guess. What are you, just redact, you robbed?
Yes, Your Honor.
Okay. All right, well, that'll cure that objection.
Judge, that brings us up to page 543 through 546.
Okay.
This is another, I believe, series of talking about, I guess, selling bullets.
Given your previous ruling, Your Honor, we'll withdraw.
All right. All right, what would our next one be?
I thought they were taking 696. My misjudge, the state was going to withdraw 696 because we already had the word slash earlier.
Is that right? Yeah. Yeah, it looks like all that is.
That's correct, Your Honor.
Okay. Thank you.
Let's see. Yeah. Judge, this one, I think we had. kind
I'm
of
sorry, this one being
I'm
which
so
one?
sorry, Judge. It's going to be page 778.
Okay.
Ms. Abbasi, in the court, for 778, the state, we won't use 778.
Okay. All right, and then is the next thing 801?
We had no objection to 801.
And that goes, what, 801, 802, I guess?
802, we discussed with the state, they were going to redact out part we agreed to an objection.
Okay.
With that redaction being.
All right.
We're going to redact, Your Honor, at the very top, the first text on page 802. And defense counsel in the state talked about this.
Okay, As long as y'all are on the same page.
That's going to bring us up to 819 and 820.
Okay.
This is another one, we don't believe there's any sort of connection to the gang and how this would be relevant. Again, this is with Free Juju, who we don't know who this is.
Your Honor, the state will, I'm double checking because
Laughing at the reference to a Hello Kitty.
yeah,
Yes.
Sorry.
he's basically insulting because the gun is
Yeah.
small.
Okay.
So Your Honor, the state will not be, I'm double checking because sometimes another thread that's captured on the same page, but we will not be introducing that
Okay.
brief back and forth.
All right.
Page 880, Judge, we feel that the relevance regarding to what the prejudice from this is, based on what the state's understanding of it is, which I don't think it's self-explanatory. Someone would probably have to explain what it means. But we feel it's overly prejudicial with respect to the minimal relevance.
All right. I think probably slide and sticks have already been explained, right? Through testimony already?
Correct, Your Honor. So the state wanted to include this just to show, it's one thing for the state to talk about it, but this is an
Right.
internal Instagram.
Okay. Overruled. What's next?
(903) 904, Judge. This was another relevance about some people talking about going to Club Crucial.
Your Honor, the person that Mr. Ryan is speaking with is the author is 05E Drive Slim. That is Mr. Christian McMiller, Your Honor, who unfortunately passed away in March of 2022. We believe is a YSL associate. So to show his connection with Mr. McMiller is why we have this.
All right. And have y'all already established who that author is, who that other person is?
We will be establishing who that is. We have a few Instagram posts, Mr. Women and other individuals with this same Instagram handle, 05E and Drive Slim.
Okay. And this would
And-
just go.
And it may already be in, there's a picture of Antonio Sledge and him,
Okay.
and I believe that picture is in evidence, Your Honor.
All right.
I'm sorry, Judge,
Go
there's
ahead.
a photo earlier on, which we did not object to, with the same person between this owner review photo.
Your Honor, the conversation continues because this is one of the conversations in which you actually need to look at his conversation with Mr. McMiller and his conversation with Billion Dollar Pink. Billion Dollar Pink towards the bottom of, their conversation actually starts in the middle where he tells her, I'm on the way to Crucial, or OTW, on the way to Crucial. Then I believe it's a she. Bruh, who you with?
Page am I looking at?
903.
Okay. It must not be highlighted.
It's not
But,
highlighted.
okay. All right. I see Billion Dollar Pink.
Yeah, so she's,
Bro, who you with?
bro, who you with? And then he responds to her, gang. So that coupled with him talking to Mr. McMiller about going to Crucial and who he's with, he's acknowledging that he is with gang to her. So these two conversations actually coincide with each other. So he's setting up going to Crucial with Mr. McMiller, and then he's
Uh-huh.
telling the other person, when she asks who you're going with, gang.
Okay. Okay. Overruled.
The next ones. Take note. They did get it. Okay. This one, Judge, is going to be 940, 941. As far as relevance, and I don't know what the probative value is. This is another one, a conversation between Mr. Ryan and somebody, and we don't know who. I don't know how it's relevant.
So this is where when we started that post where it says love all of and has the snake emoji, one of those individuals that Mr. Ryan ats is Block Life OKKY, which is who he's speaking with. So it's someone he's publicly stated as a fellow gang member. And so what he says is at the very top of 940, this individual Block Life says, talking about going to Club LaCroix, about to get dropped off at Big Nick's spot. Big Nick's spot is someone that pops up in terms of a location that that YSL members will go to or hang out at. So, and it's 2830 Waters Road, which is the same house that's we've talked about to the court with the 911 call and tethered to the murder of Shamel Drinks and the back and forth. So also, if you follow this conversation more, Mr. Ryan in kind of the bottom of 940 says, Slime's person responds like, who? Mr. Ryan uses this term MAJA, but then if you go further, he's like, what studio are they at? And he says, last time I checked, they were at Club LaCroix with Dolly, the sister of Jeffrey Williams, about 2 hours ago. So again, this is showing it references a couple of different items in a private Instagram thread of a location of Waters Road, referred to as Big Nick spot, and also tethers, because age-wise, there's a difference. And so it connects Mr. Ryan with other evidence in this trial.
All right, overruled.
And Judge, just to add to that, the part about who was with Dolly, that's person is. I'm sorry, did I miss that? We do know who that is?
I don't know his name. I know it's the same person that Mr. Ryan ats when my slimes. And then Mr. Ryan responds to that, okay.
Yeah. All right, thank you.
This is 950, 951. Seems some sort of spat between Mr. Ryan and somebody else. At the somebody else, I don't think we know who it is. So I don't know what the relevance of this is.
So, Your Honor, the state for 950 and 951 will not utilize that
All right,
thread.
thank you.
Or 1012.
Okay.
through 10 and 14, again, we have another firearm gun conversation.
Any significance beyond?
Your Honor, no, the state understands the court ruling that there's one, and the court's ruling may be the same on this at the bottom of 1013. He says, can you sell me some for cheap? You have 2 sticks and about 5 pistols. And then Mr. Ryan says, for sure, we're going to be getting into photographs and videos of firearms, but so the state felt that was significant in terms of the number of firearms and also, but the murder involves both what would be referenced as a stick or a longer assault thread that he's talking about, the weapons involved in the, nonetheless, the state understands the court's previous rulings about firearms, but that specific.
Shows his access to firearms like the ones used in the murder.
Yes, Your Honor.
That one.
And the state cannot, thank you, Your Honor, will not use 1012 when he's talking about a different firearm, and we'll use 1013.
Okay. And then does 1014 go with it as well, or is that some new thread? Y'all don't need that one, right? It'll just be page 1013.
Yes, Your Honor.
Okay.
Judge,
Yes.
I want to go back to 1013.
Sure.
This conversation is Free Juju saying he wants these guns, which the state is saying, are consistent with what were used. And Mr. Ryan's response first is prior gun or unnecessary. Give me the and then Free Juju says, when you get 2, just give me 1. And we don't have a response from Mr. Ryan saying, okay, yes, I'll do that. He's actually saying, no, I don't.
Saying, no, I don't have those guns. So the ruling stands.
That's 10, 13, and 14.
Well, my understanding was that they were just going to use 1013. Do you want 1014 in?
I was just trying to make sure I got the right pages.
Well, all right. Let me
That's
know,
correct,
Mr.
Your
Ryan.
Honor.
It's just 1013?
Yes, Your Honor.
Okay. All right. What's our next one?
We took out 1036 and 1039. Your Honor, if the next 2 pages were 10, it's just 1039.
I'm sorry, Judge, to back up, if 10, 12, and 10, 13 are coming in, then we would want 10, 14.
Yeah. Yeah. Okay. So my understanding was it would just be 1013.
Like 10, 14 to come in because it completes the conversation of I don't sell that anymore.
Okay. So 1013 and 1014.
Your Honor, we're withdrawing, am I looking at the over? We're withdrawing 1036 and 1039.
And Your
Okay.
Honor, the court's version just currently has 1039.
Okay. And y'all are withdrawing that. Okay.
Yes, Your Honor.
So then that takes us to 1070. Is there, which I guess would be 1070 through 1073.
The next objection. 1109 and 1110. This is largely a conversation with somebody else. And I don't think without the co-conspirator that this is relevant. And I also don't think the relevance of this conversation is evident or has any relevance unless there's someone who's going to get up and say, this is what this person 1110.
All right.
So, Your Honor, there's multiple things going on here in terms of 1109. This person says, he tells Mr. Ryan, hey, Slime, you need to check out this person. He's my brother. I'm trying to scare him. And then Mr. Ryan says, does he say he's Slime? As in, like, is he claiming YSL? And then he says, how? And then the guy responds like, yes, he is, but he's my brother. And this thread goes on. And he says, the person who started this conversation says to Mr. Ryan, I just want you to scare him, which the state takes as not, do something more violent to him for if he's really not Slime and he's claiming that. And then the bottom of 1110 is a separate relevant portion where Scarface is Demikion Garlington. And when that Instagram handle, it says slat this SB, what's up? The state believes that SB is the nickname for Mr. Stillwell. And so that specific bottom portion of 1110 is a separate reason in this thread. And then have a video call with one another. And so there's two things going on, and the state can not utilize, so.
The top part.
No. So, and Your Honor, the part of what's behind this is, like, for example, Mr. Sledge, who's testified before this court, he's on the stand saying anyone can be Slime, the judge, the state, whoever. And so this is a private conversation where it's clearly a problem that someone is publicly saying that they're Slime, because Mr. Ryan is saying, like, he says he's Slime, how? And the person who's telling Mr. Ryan about this says, I just want you to scare him, which the follow on is like, don't do something more. So that's why the state feels it's important, is there's a differentiation. Not every, there is people that are Slime, there's people who aren't. And so, and it's a problem if you're saying you are and you are not.
Okay.
But there's no response from Mr. Ryan saying, yes, I'll do it, or I don't know what you're talking. There's no response. This is someone else, these things, whether he's going to scare him or do something like that.
I have removed other threads, but I believe this ultimately gets to the point where he says, and I'll try to find where this is. There's a message where Mr. Ryan says, like, what do you want me to do? Kill him? Like, and so I'm pretty sure in my mind I don't have that included, because the state's trying to be judicial with what we include, but I'll try to find where that is. So it's not, because my thread is only what we're going to use, but I want to double check, but that is my memory. So I'll verify that right now. Your Honor.
Okay, well, assuming that that's the ultimate response, they could add that response, or we could have an understanding that there is a response that affirms that he's willing to do something.
I'll have to check, Judge, because those
Okay.
pages aren't in here.
Your Honor, I
Yes.
have a concern with this matter, and maybe I'm just not as tech savvy. We're seeing towards the bottom of the page the initials SB show up.
Yeah.
And Mr. Atkins, I appreciate him being clear on this. I'm being told anyways by the state that this SB conversation, whoever's involved, is a separate thread, is what I heard, from the
Yeah, I
discussion
hadn't
about,
gotten clarity on that, so let's, I'm
Well-
as untech savvy as you. So is the person who's saying this SB what up able to see this other conversation?
No, Your Honor. And so to accurate, well, with Instagram, there's a text thread ID, so they give a specific number.
Yeah.
So if I'm texting Joe Smith and then a second later, someone else texts me and me and Mr. Smith keep texting back and forth,
Yeah.
each thread, you have to search the number. So
Okay.
this is a completely separate, it's almost like getting a whole other text message.
Okay. Is that why some things are in yellow and some things are in green highlighting?
Yes, Your
To
Honor.
show that this is a different thread?
That, and to also help be clear for both the state defense and the court of what portions, because you're always going to have, for the most part, random conversation in
Right.
one page.
Okay.
And so there will be no evidence or inference or argument that what we were just talking about has any connection with this Scarface slap, this SB what's up, and then the video called Mr. Ryan. Those are independent.
so when the state's presenting their case, I'm trying to think through this. If this is, say that over objection, the part we just discussed involving Mr. Ryan and I just wanted to scare
Right.
him part. Say that's admit, for example,
Uh-huh.
that's admitted, and then the lower part involving slap this SB what's up is admitted. When we're publishing to the jury, is this going to be like printed out as two different exhibits with two different text chains, or is the state's plan to just publish this document and then this jury kind of is supposed to figure it out? I'm trying to understand where we're going with this.
No, Your Honor, we would have the witness distinguish that with Instagram, there are different conversations, this is a separate conversation. We can ask that very
All right,
specifically.
y'all need to just make that very clear that, because, I'm sure, well, I'm not sure, but there might be jurors who are as untech savvy or unsocial media savvy as Mr. Sharp and I. And so
And
we
we can
need to
highlight
make
it
it very clear that this is an entirely separate conversation, that the one who says the zest is in no way, seeing or involved in that conversation. Yes. All right.
Your Honor, back to the part about the conversation, I'm brother, what do you
Right.
want me to do, kill him? The response about killing somebody is a different conversation with a different person.
So, Your Honor, I was just control Fing to find where this is. So we haven't gotten there yet, but a couple pages after this is another conversation where Mr. Ryan is talking with someone else, saying that someone's not official. And then he says, he's not. Do you want me to kill him? So that's why I prefaced what I was saying to the court of I want to verify this, but it
Okay.
is,
It's a
we're going to
different
get to this.
conversation.
It's a couple pages from where we are.
But is
currently.
it the same two people?
No, it's a different conversation where he's discussing someone who is or is not slime. So I apologize for that. It's 2 or 3 pages after where we are.
Yeah, the conversation about the brother, that has no response from. Mr.
Okay,
Ryan.
well then, if this next conversation is showing the same thing, and this is more clear, use the next conversation and withdraw the.
Yes, Your Honor.
Or I'll grant the objection.
And just be intending to introduce the part between where it says, hey, this is SB,
Okay.
which would also
Just-
eliminate the problem we were just discussing.
Okay. So they're going to withdraw that, and for that purpose. So I guess when we see it in trial, nothing will be highlighted other than the, this has up, and then the video indicator. With that. Take care of the potential confusion issue.
Well,
Seems,
I have a confusion issue and then I have a relevance. As I understand understand these records,
Mhm.
and I'm focusing on the part that says SB because that's allegedly something my client goes by.
Okay.
Is that better? As I understand these records indicating someone types or texts this SB what's up, this SB what's up, and that the author is showing Scarface because that's the device that's being used on Twitter. Is that
Your Honor, so here, account, this SB hit me up or whatever. I think he said
Okay.
hit my line in a few minutes. And so I think that is probably what occurred.
and then okay, so by the state's theory, Shannon is on Demikion's Twitter and
Right.
Instagram. Yes, I'm sorry. Thank you. And says something to Ryan, and then afterwards there's okay.
Correct.
I'm going to object to. I understand that it's being separated from
Right.
other discussions, but that in of itself, I'm going to object for relevance grounds. I don't think there's an issue at this point whether Mr. Ryan and Mr. Stillwell know each other, or Mr. Stillwell and Mr. Garlington know each other. So, I mean, there's no content to any of this. It's just some sort of connection.
You're right. I don't believe, and I'll double check. I don't believe we have any evidence of
Mr. Ryan and
Mr. Ryan and Mr. Stillwell. We have a picture that I think is in dispute, but outside of this picture that we believe is in dispute, and him, but there's a dispute as to whether the individual is Mr. Stillwell or not. And so outside of that picture, this is what we have to show association.
I mean, at least
Okay.
as far as since I've been here, I don't think we've had that evidence.
Okay. Well, I'm going to say that picture that the state's referring to is definitely not Mr. Stillwell.
Okay.
So,
All right.
okay, so, and just getting back to, I'm just
Asking and what Mr. Shard is asking is when page 1110 gets presented, the only thing highlighted will do it at that point.
We'd rather have it just redacted out to be safe.
Okay, so are they going to come in looking the way they do with just highlighting, but other?
Yes, if they would
Okay.
let us know what we're
All right, thank you.
and sooner rather than later, as this case may come up sooner rather than later.
We'll double check it, Judge, and
All right.
speak to the state about that. It sounds like,
They don't have I mean, they don't need it anyway, so they wouldn't have a problem with it.
Right.
Okay. All right, what's our next?
the conversations from 1:15 through 1:17. Another conversation with Free Juju. This is the one where they say something about killing someone, and we do feel that that is overly prejudicial to be coming.
So, Your Honor, this is the conversation I mixed up with the first one where you see the- and then in response, Mr. Ryan at the bottom of page G and 7 is G, seventh letter of the alphabet. And then so they're kind of going back and forth. And then when you follow just Free Juju and Ryan, that's why I highlighted, because it does get hard to follow. On page 1116, this after Mr. Ryan, after this Free Juju says, hey, this is who you let be Slime. And then Mr. Ryan kind of shoots back, this is who you let be Blood Gang. And then he responds, he says, well, he's not official, but he says he be in 50. And I think when he's 250, Cleveland is a location. And then Mr. Ryan basically says that's not true. It's a slang term cap, as in that's just not accurate. And then the very last.
Weighed by any undue prejudice. Okay, what's our?
Leave. $11:55, 59. $55 and 59 are more kind of gun back and forth.
Checking, because we're in February 12th and the murder is February 23rd. So these conversations start to have multiple purposes.
Okay.
But long story short, the state initially highlighted this with talking about revolvers. So the state will not be introducing 1155
Okay.
and on of that conversation. So the state will not introduce either of these.
Okay.
I'm sorry, Judge. The highlights on here, I'm not sure of the relevance on page, the highlighted conversation.
Does that pick up anywhere after that?
Your Honor, 1172, and I missed the highlight here. It is, again, the Scarface
Yeah.
Instagram and Mr. Ryan texting back and forth. So I meant to text. This is included for the Scarface Instagram says he is messing with Mr. Ryan Slat. We're locked in, little brother. And then he ends up saying, hit HML, hit my line whenever you need me. And then Mr. Ryan says, for sure. So 1172 is just the start of that conversation. And, that they start out talking about some type of suit or clothing that
All right,
they
that,
bought.
that doesn't seem particularly relevant.
Yes, Your Honor. So can we not, or the state will not use 1172. This would like to use 1173.
Hadn't you already established their relationship?
Well, Your Honor, the first message was, which is the first evidence, well, Mr. Ryan.
Okay.
And this is showing like, and he's using Slat. He's saying, I'm messing with you, Slat. We're locked in. Hit my line whenever you need me.
So this is actually Garland.
That's the state's understanding, Your Honor.
Okay.
Okay.
All right, then that's admissible.
Excuse me, Your Honor.
Yes, sir.
May we take a short bathroom break?
Yeah, it seems, I don't know how much longer we have on this one, but yeah, that'll be fine. Let's take a quick break.
Hey, everybody, thank you so much for watching our coverage of the Young Thug trial. Now, I want to take a quick second and I want to tell you about this stream's awesome sponsor, Upside. So what's Upside? Upside is a free app that gets you cash back on daily essentials like gas and groceries. So when I go to pump my gas, I can use the Upside app and get cash back, real cash back. It's money that appears in your Upside app that you can transfer straight into your bank account. So once you have the Upside app, you claim an offer from the app and you get paid. And as you saw me just do, you can use Upside at places like Shell, Exxon, Mobil, 7-Eleven, Taco Bell. That's just to name a few, by the way. There are so many more. So to find out how much you could earn, click the link in the description to download Upside. And use code LC every yes.
maybe 5 minutes, we might be able to make some progress
Okay.
within ourselves on the next. We have this 100 and something pages of Mr. Ryan and another however many page document. Another 17 pages. We may be able to, based on what we talked about, make some progress before bringing it to the court if we can, maybe 10 minutes.
Yeah, that'd be fine. Do y'all want to do that? Do we want to just skip ahead to something else, or I'm confused?
That doesn't matter.
And y'all could do that over the lunch break?
That's fine.
Okay, because we only have so many hours court time.
That's fine.
All right, so what should we move to? Because I definitely, if y'all can come to agreement or narrow down, that's wonderful. But if there are some things that we need to discuss anyway, let's just move on to
We need
those.
to finish up the document that we're on.
Okay,
We'll skip another one of the documents and move to it.
all right, sounds like a plan. Okay, so I think our next thing was going to be 1177 is where we stopped. Any objection to that?
No,
All right, so do you know where the next one you have objection to is?
one is going to be.
Are y'all withdrawing 1202 since it appears to only
That
have,
was our next objection.
Yes, we'll
All right.
withdraw 1202.
all right. Then,
And then we go up to 1169, excuse me, 1369.
okay,
Where we have somebody else telling our client that Bali, that's the co-defendant, or co-defendant on the murder case and on this case,
mhm.
is locked up. And that, I believe, to the next few pages in here are other people telling Mr. Ryan that things are going on, people are looking for you, stay safe, things like that.
Right,
They're not Mr. Ryan.
okay,
Your Honor,
uh-huh,
this portion, so, and I'll start with 1369. It is at the very bottom where the co-defendant Blaylock on this murder's nickname is Bali. And
mhm.
so Snake Life texts, or not texts, but messages Mr. Ryan.
All right, what date is this?
This is 3 days after the murder, so
Okay.
February 26th.
All right,
And he says, Slime, Bali's locked up for that shit. And then the next time that they message Snake Life and Mr. Ryan is on page 1371, where Mr. Ryan says, he says that's crazy. Like, he doesn't respond. What are you talking about? What me and Bali did, or what, and this is 3 days after the murder. And then, so, cause you have to kind of take, in my mind, each thread, because what also,
y'all may want to
Your Honor.
highlight the different threads and different colors, so it's
yes, Your Honor.
clear.
Yes, Your
This
Honor.
is one, and here's the other one. Okay,
The next one is this Instagram handle of DeAndre Smith.
all right, so is that the extent of that conversation then?
And then it goes further on 1371 at the bottom, where Snake Life, the same person, says it's a warrant out for
Okay.
you, Slime.
All right. Okay. And that's the extent of that conversation then, is that right?
Yes, Your Honor. But it concludes with a video. In Instagram, you can see a video call event. You don't
Okay.
know how long
All right,
or what
and
was.
are y'all, is that highlighted, or are y'all going to highlight that
Yes, Your Honor.
in a color that is unique to the two of them?
Yes, Your
Okay,
Honor.
all right, so that's relevant and appears to not just be a one-sided conversation. All right, so let's go back up to whatever the next thing is. So-
Yes, Your Honor. On 1370,
Uh-huh,
you have DeAndre Smith, who
saying hit me up and stay low,
correct,
and then 911.
correct.
And then what happens?
There is a video call of 1370 between Mr. Ryan and DeAndre
Okay.
Smith.
All right. So that one would be the same ruling. And then do we have a third thing going on here or?
The state, I have highlighted a message from Dirty Stick that says be safe. The state would not be using that. So I'm going to remove
All
that
right.
highlight.
All right. Thank you.
Judge, I guess just backing up the messages which are one-sided with DeAndre Smith. I guess I think that's what it is. It is one-sided, not, I don't believe there's any response from Mr. Ryan.
Well, what Mr. Atkins just said was there's a video call after that.
I
Video
don't-
call event.
I could be wrong. I don't think it shows whether that video call is answered. I think there's an attempt to make one. I could be corrected, but I don't think there's anything which shows that the video call did actually take place or that it was answered.
Your Honor, I don't believe that that is ever captured in Instagram records. Like it shows a video call event and nothing more, is my understanding from having reviewed other Instagram records. That just that's how Instagram captures it. It doesn't, it's not like a call detail record where
Right.
it says like call completed or that's all you're going to get, which can be argued, I believe, by, like when we introduced this, that could be crossed. I don't know if they actually spoke, but it's the state.
Okay.
So
I mean, I think it's even though, all right, yes, so but you will highlight the video call event as well.
yes, Your Honor.
Okay. All right, I'm going to permit that.
And
What's our next thing?
I have an additional I'm sorry, Mr. Atkins, did you say you were going to take out the other conversation in
Yeah.
1371?
From 1K Dirty Stick.
Thank you.
Yeah, that's what he said. All right, so where do we go next?
I believe 1372 and 1372, Judge, I believe is, again, a one-sided from ESPN self-made telling Mr. Ryan, stay where you are, don't go to the house. And there's no response, I don't think, from Mr. Ryan. So it's just hearsay, and we don't know if there was an effect on listener.
Your Honor, I was trying to, and I may have not included this. I can't find where I have Mr. Ryan's response to this in the thread. I may, when we have this break, look up the original thread to see if he ever responds to that.
Okay. So you can get back to us on that one.
Yes, Your Honor.
All right. Then what would be next?
Your Honor, the next few pages. I don't know if there was anything on 1373.
1373. It doesn't look like it. So with 1373 and 1374 is, I mean, they're in here, but
Yes, Your Honor. So 1373, there's more video calls between that DeAndre Smith and Mr. Ryan.
okay. So they're not highlighted, but you would highlight them?
Yes, Your Honor. I intended to, I missed something when I was going through, but forgot to highlight that. I included that one.
All right. And it continues on to 1374 also? Or is there a reason 1374 is in there?
So 1374, it partially continues. There's a new thread as well, and I'll highlight this, or messages through Instagram. DYN finesse and says, hey, this is Little Rod. Can you help me get a lawyer? And then he's messaging another person saying, hey, this is Little Rod. Can you help me get a lawyer? And then he messages back to that DeAndre Smith, who he's been video calling with. And he says, this is Little Rod. Can you help me with a lawyer? So it's after all these people are saying, hey, there's a warrant out for your arrest. And some of these individuals, like, for example, the DYN finesse, there's other photos with Mr. Ryan and that individual.
Mhm.
And so that was why the state included this, was after all of this notification about the thing that him and Bali, hey, Bali got locked up for that stuff.
Uh-huh.
He speaks to all these people, and then he's reaching out to various people to try to get a lawyer seconds later.
Okay.
Judge, I just don't think it's appropriate that the state is trying to use against him asking for
His
a
constitutional
lawyer.
right to have a lawyer, agreed.
Yes.
I'm going to exclude that if that's all that's for.
Yeah. Understood, Your Honor. There was more connection, but I'm not articulating it well in terms of these individuals and their connection, but understand the court's ruling will not use this.
Okay.
Okay, so 1374 is out.
And I think, well, they're right. So that would be 1374 through 13, what? Is that it? Just 1374 then?
Yes,
Okay. All right. And then so 1376 then is something new. Is that right? Okay. And is there an objection to that?
I'm not sure, Judge, on if the state, at least this one, is trying to assert that this is one attribute this to Mr. Stillwell.
Draw this.
Okay. Withdrawn. All right. 35.
Implicated parties who we would have no objection or no valid objection to saying they shouldn't come in, and also will be duplicative in a date. So with
Okay.
the
We can-
balance of this,
We'll just circle back to
correct,
if needed.
I
Okay.
agree with Ms.
So then are we done with this document
we are.
for now? Okay. All right. Focus.
We had objections to the document, which is Mr. Blaylock's Instagram. It's in that same Dropbox folder.
Okay. Can y'all point me to,
Yes, Your Honor. It's Blaylock Instagram
yes,
reduced.
got it. And it's like 109.8 megabytes. Is it that one? It's a PDF?
Yes, Your Honor.
Okay.
Yes.
All right. And Blaylock was his co-defendant on this case, right?
Correct.
All right.
Yes, Your Honor.
All right. Right. And,
Also a defendant in this.
right.
Right.
Yeah. Just a severed defendant. Yeah. Okay. All right. I have that open. So if y'all want to give me the page references where there is objection.
Judge, I believe, so we have no objection page, the first photo, 89. Pages of Ms. Block. Oh, sorry, there's some photos that page 91, this is relevance. I don't think we know who the other person in this photo is. So outside of that, we have just Mr. Blaylock.
Okay.
Your Honor, I'm pulling up right now. So, Your Honor, this specific photograph, that Snake Life handle where he puts right hand messages Ryan, what I wanted to go back and check was if some of the admitted threads we introduced, because the state wants to show that they have, interact with the Snake Life is in Mr. Ryan's Instagram. I just want to double check with what we've just went through, if it's still included.
Okay. All right. So if the @SnakeLife handle is one of the things that came in as a communication with Mr. Ryan, you want to show that whoever this person is @SnakeLife also Mr. Blaylock.
Correct, Your Honor.
This document, I have the same notes on that. There are, again, we don't have a good argument or any valid argument that conversations between Mr. Blaylock and other implicated parties in the murder, Tahira Hartsfield, we have no objection to those back and forth between Mr. Blaylock and Ms. Hartsfield.
Okay.
Conversations with Mr. Ryan. I believe everything else in here is Mr. Blaylock, who's obviously not sitting here with us, and unknown people. So I don't see how those are anything except rank hearsay and would not be admissible here. Again, it's Mr. Blaylock, sure, but he's not here.
So, Your Honor, and just to orient the court of basically, part of these Instagram records were part of just the murder itself in terms of who's messaging who. And I say that in terms of there were some other females involved and they were in their others with what is not covered in messages between the other people involved the night of the murder or Mr. Ryan is for, and I'll explain what I'm, co-conspirator hearsay in furtherance of the criminal street gang. So, and I don't know where,
If I could pause one moment and add to that,
Okay.
Mr. Ryan and Mr. Blaylock are not charged with participation.
Henry is
Rico
Why-
by being basically, right?
so, yes. So the state still, it is improved, very relevant, I should say.
Okay, so I think if the response to the hearsay objection is that it would come in under the co-conspirator exception, then I would need to kind of look at what we're talking about.
Yes, Your Honor.
Right.
I agree. And so the find that involved.
Okay.
And if the defense wants to, does the
Y'all wanna
court?
get together on this one also? So would that be more helpful?
I think we just disagree. The state says these are co-conspirator. They come in and we say we have no idea who this.
Okay, well then, I mean, if you can point me to which ones we're talking about in this, however.
The first one is going to be page 224.
Okay.
Nothing's highlighted. I don't know what. I don't know.
What is 224?
So
Do
Your
y'all,
Honor,
are y'all ready on this or do you need
Yeah,
to?
no,
look? Okay.
I'm ready, Your Honor.
All
I
right.
just, the 224, I believe, oh, I know why. So we don't need this. He puts his phone number in
Okay, we don't
224,
need it.
but
It's out. What's next?
236, the next page.
Okay.
So one, his Instagram changes, but for the court's awareness, one King DO1 is Mr. Blaylock's Instagram. So at the bottom, when BB Fredo said, just from C, though this and page 238 says, how do you murder? They explain about meeting each other, playing basketball, and why he speaks. I did not know you were Rolac till now. And he says, he asked if someone, his name is Huncho, is still rocking right. And then Mr. Blaylock responds, yeah, he's still Rolac, he's G. And so that particular back and forth is specifically about, which, in the indictment, it says YSL Criminal Street Gang, conversations between two people who within this text thread are identifying themselves with Sex Money Murder Street Gang. They're asking the specific person is still rocking right. These are private Instagram conversations, and for the jury, with Ryan and this overact, Blaylock and Ryan's gang affiliation in connection with one another is relevant. And so the state is, with these in PDF of Blaylock, believes that this conversation about information about Sex Money Murder and other members, and when he's saying, is someone still rocking right, is he still in good graces, is he still, and they're confirming and validating with one another. Those kind of conversations happen frequently in a street gang and are necessary to know who's in the gang, who's not, and to, so this specific thread is specifically about the Sex Money Murder conversation. And that goes up to page 239. There's a separate, 276 is a separate conversation.
Okay.
And that would be very good evidence against Mr. Blaylock, who's not here.
So, Your Honor, in this trial itself, there's been conversations from APD gang detectives about Pete Rolac, Sex Money Murder, the two pistols, and there's been a plethora of both state questions and cross-examination all about that. So having a private conversation with Blaylock, who the state believes the evidence will show, committed this act with Mr. Ryan, and are YSL members, and in, which is a subset of the Sex Money Murder Criminal Street Gang as well. This is relevant because here in this thread, he is using and saying things privately with another individual he was locked up with in YDC. And even though Blaylock is not in this trial, it's relevant for the jury to understand that this is severed. He would be trial, has the same gang affiliation, and both YSL and Sex Money Murder as Mr. Ryan, which has also been attributed to other defendants in this courtroom through testimony by APD gang detectives or social media. And so that's why the state wanted to include this specific portion, and specifically feels that because they're discussing criminal street gang, it furthers the criminal street gang because gang members need to be able to recognize one another and know who else is a member. It's not specifically about YSL, but it's about Sex Money Murder, which is been, so that's the state's on this specific thread.
There are a lot of relevant things. They're not necessarily admissible.
So the thing that is causing me some pause with this is that it's just this one conversation, right? And you're saying it should come in under the co-conspirator exception, and yet doesn't there need to be something outside of the conversation that establishes this other person's participation?
So, Your Honor, it's whichever individual statement is being utilized as an exception to the co-conspirator hearsay. For example, anything that Blaylock states. The state, to the court's point, anything that Fredo would say, the state's position is, and again, it is kind of like line by line, because I'm not going to be presenting other evidence outside of this text thread about Fredo and their gang affiliation. So the
Right.
state is relying on evidence which is in this Instagram or other evidence in the trial about Blaylock's gang affiliation, his
Right,
statements,
yeah,
and the
Blaylock,
effect on him.
not so much, but
Yes,
how
Your
about
Honor.
the other person?
So I will not, there's no other evidence that the state will be presenting or can proffer about specifically Fredo's sex, money, murder gang affiliation.
Okay, then how does this come in, or how does his part of this conversation come in?
Your Honor, the state would view what Fredo is stating is necessary to complete his responses. Like, for example, on page 239, it's Fredo who says, he asked if this individual, Huncho, is still rocking right. I don't know who that individual is. The state has to assert whether he is or is not, but Mr. Blaylock responds, yes, he's still Rolac. He's still sex, money, murder. He's G. And so whether you could insert any name for Huncho, it could be Fred, John, that same response by Blaylock of saying, yes, that person you're talking about, he's still sex, money, murder. That's why the state wanted to introduce this thread. And so Fredo's responses, the state believes, are necessary for context to Blaylock responding back. So have either a non-hearsay purpose or kind of necessary to complete Blaylock's response. Because if you just introduce Blaylock saying, yes, he's still Rolac, he G, you don't know what he's responding to. And the state for, just page 239, that, exchange, I think, is the best example of how the state, to get through hearsay, co-conspirator statement of Blaylock, and context to Blaylock's responses for Fredo on this specific text thread.
So what do you actually need of these 3 pages?
So, Your Honor, I think 239 is one of the more important of this specific thread. And the state could do without, or could, the state does not have to use 236.
Okay.
And then 238 at the where Mr. Blaylock says, how did you know I'm murder, sex, money, murder? And then would include 239 where that bottom portion, where he's asking if a specific person is still rocking right.
Okay, so bottom of 238 is Mr. Ryan saying,
Mr. Blaylock, Your Honor.
I'm sorry, Mr. Blaylock saying, how you know me, I'm murder.
Yes, Your Honor.
And then the response is, but I didn't know you was Rolac till now.
Correct. And they're somewhat interchangeable in terms of Pete Rolac founded Sex, Money, Murder. So sometimes they'll say, I'm murder, I'm Rolac. And then after that, this Fredo is asking Blaylock if a specific person is still rocking right. And Blaylock responds, yes, he's still Rolac.
And he's So it is that Mr. Blaylock can affirm someone else's gang affiliation
In specifically second murder, yes, Your Honor.
because he is also.
Correct, Your Honor.
Is your point.
Yes, Your Honor.
Okay. Yeah, I mean, I guess if the only thing. So could you do without but I didn't know you was, well, I guess not, because that's your whole point.
Judge, I still don't understand how we're saying acceptance or here's prohibitions here.
And
Well, you don't understand for Frida or for Blaylock?
We don't have Blaylock here right now. I understand he's charged
He's a.
for Frito. No, I'm sorry, for Frito, yes.
Yeah, and I think that what the state's response is that you need both sides of the conversation to understand what is being offered what's being offered with regard to what Blaylock is saying, which is, I mean,
Judge, given the speculative probative value trying to piece together what this is saying on both sides, we would ask it be included under 403.
frankly, I'm trying to piece together all the different abbreviations.
Right.
Which I guess young people know, but I'm not young. It's all relative. Yeah, I think it might be better to just exclude this.
yes, Your Honor.
All right, so then our next one is
276.
276. Okay,
Now, Blaylock says he's talking to someone new. And
okay,
he says, why the hell you didn't say you were slime when we were locked up? He's talking to someone else he was locked up with at YDC.
okay.
And then the person responds, I didn't know you were slime. I just thought you were blood slat. And then Blaylock responds, I'm an OG in that slime shit.
Is there any objection to that?
Don't believe so, Judge.
Okay, where's the next one that we have objection to?
Believe the next one is going to be Judge, I guess I'm trying to make sure, are we saying anything that Mr. Blaylock says comes in?
I mean, in terms of him being a co-conspirator.
Right, conspirator, but it has to be a conversation between two co-conspirators.
You're going to need to me to next objection is, because I'm not going to know what conversation we're talking about otherwise.
The next one is going to be 292 with hot shit
Okay.
is the name.
And so, Your Honor, on 292, Blaylock's nickname is Biley. So that Instagram handle that ends in LIJRR says, hey, Biley. And then he says, a young person who stole the Mustang from CEP. He's trying to orient Biley to who he's talking about, to Blaylock. He says, he's trying to put me in slime, but he said, I got to get put in by you. And he's talking about getting put in the gang, the street gang. and when he says, or go to 250, he's talking about 250 Cleveland. So if you follow this a little further, they continue speaking, and Blaylock says he's going to have to give him money, $25. And then he responds, I'm getting in the fire, right? And Blaylock, and he says, I'm trying to be real right. Again, that was that earlier, real right means like I'm trying to be like official blood. And in this context, official YSL. I didn't want anyone coming up to me talking about I'm not real slime shit. Oh, you're going to be real slime. On slime, you will be. And then the person says, all right, say no more, SNN, saying, say no more. I am on Cleveland. Where you at? I'm on Cleveland right now. Blaylock's Cleveland. So this is into a criminal street gang because Blaylock is about to put this person in the gang. And he says, and the guy's like wants to make sure he's officially a member of YSL, and Blaylock assures him, you're going to be real on slime, you will be. And then they talk about meeting up to complete this conversation in person, or do what they need to do to get this guy in the game.
Okay. And so once again, how is what the other person is saying?
So, Your Honor, to me, it completes the context of this thread. So and looking at this line by line in 292, the first thing he says is, hey, Bali. So whether he means hello or goodbye, that statement is neither here nor there. And then he's orienting Blaylock. I don't know who he's talking about, the person who stole the Mustang from CP, because Blaylock right above that says, who is this? And so he orients him to a person. You might as well just take that phrase as a name. Instead of saying John, it's this person who stole the Mustang from this other person. And he says that person is trying to be in slime, but said, I got to get put in by you or go to 250 Cleveland. And so for the jury to understand why Blaylock responds, you're going to have to give me $25. And then they continue speaking about, and for Blaylock to say, you're going to be real on slime, this whole conversation is about this individual trying to officially become a part of YSL. And so the state feels that Blaylock's statements are in furtherance of the gang, which needs members and continuously recruits or gets new members. And everything that this other individual is saying is necessary for Blaylock's co-conspirator statements to be understood. The state's not arguing that this LILJRR is a part of YSL because the whole of this conversation is the end game. The state feels that in terms of true hearsay, Blaylock's is in furtherance of the gang because he has to speak with, they have to meet up, and he's literally saying, I'm going to put you in officially to the gang. And what this other person says, whether he, whoever this person is that they're trying to orient about stole the Mustang, or when this person is asking him, I'm trying to get put in slime, but he said, I got to get put in by you. Whether that other person said that or not, that orients Blaylock's responses, which again are to further the gang by getting a new member that's properly verified by Blaylock.
I might have to come back to that one. I'm going to have to give that one some thought.
Yes, Your Honor. The state is not going to use 338, which is PDF page 15. Instagram page 338.
Okay.
On 342, Blaylock is asking Snake Life Maniac, which is a double reference to both YSL with the snake, and then, you know, when he's crossing out the C, put an X, nonetheless, like, who are you? And murder. I'm YSL and I'm sex, money, murder. And then immediately he asked the person who stamped you in slime, who basically made you official in the street gang.
Mm.
And the person basically is like checking him right back and saying, well, who stamped? I've never seen you on Earth. And then Blaylock says, I'm on Cleveland all the time. I stay on the avenue. And then he says, I'm a big dog. Ask me. My name holds weight on Snake, as in, like, I'm higher ranking in the gang. And then this person responds, I don't really be seeing you around. He says, I'm Maniac, and you can ask anybody on the avenue. My name holds weights too. And then they asked, who stamped you in? And Blaylock says, Pokey. This is the same Pokey who, in the interviews of the shooting of wife and Lucci's mother, were talking about Kenneth Copeland when they were at Big Boo's house and they got the call about $10,000. That's what those statements of Zachary were talking about. It's the same Pokey. And so he's saying, I literally got stamped in the gang by Pokey. And then this guy's kind of trying to verify this because he's like, well, you know, Pokey locked up for 6 or 7 years. Like, when did you get stamped? And he responds back to him, Gorilla stamped me. And Blaylock says, I was YL, which is Young Loyalty Rock Crew, raised on Cleveland Crew. And they continue speaking. And the guy says, I never met the Young Rock Crew. I just know Big Eye and the rest of them. And then Blaylock kind of verifies, he says, I be with one of them, like, obviously with them. So this whole conversation is them checking one another for, are you legitimately YSL, etc., by the way that they're speaking. And so they list who stamped them in the gang and, you know, mention kind of how they knew each other. And so this whole conversation is, again, it's the larger conspiracy of the criminal street gang. Doesn't have to be tethered to, in this specific context, is also part and parcel of the RICO criminal enterprise. They're kind of one and the same. States alleging is putting that this criminal enterprise is YSL, which is a street gang and a criminal enterprise. So this whole conversation is in furtherance of the criminal street gang. Because, again, you have to have a way to verify and check who's a member. Because if someone is a member, you can trust them more if they're not a serious problem. And so this whole conversation furthers the criminal street gang enterprise because they are trying to verify one another. And is also Blaylock stating all of these things and actively claiming his gang affiliation, which, no, being a member of a gang in and of itself is not a crime, but in context just like the one we're in, these kind of conversations, you know, also go against his own interest when he gets charged later on in this exact RICO.
Mhm.
So for those reasons, the state feels that this conversation is co-conspirator hearsay for both parties because of the way that they're using specifically YSL gang identifying language and verifying one another, which that kind of conversation is a conversation that furthers the gang. And so that's the state's position for this specific conversation of why it's not hearsay.
Judge, I understand all of that. This conversation established this conversation. The co-conspirator hearsay exception. There has to be something besides this conversation. And we don't have anything.
Yeah, so I've got a question about that. And can other circumstances that are can other evidence corroborative of what is going on in this conversation be what establishes the existence of the co-conspiracy. I mean, the fact that they are talking about things that we know from other evidence, is gang related and is specific to this gang and things like that.
Your Honor, the answer is yes, in terms of, for one, if you started a trial with a co-conspirator, pre-trial, you have a motion in limine, and you say the state wants to introduce this two gang members discussing, just think of the most perfect example of something that would fall into A1D2E. You could introduce the statement as the first piece of evidence with the proffer to the court that this evidence will come in to prove it. At this stage of the trial, in terms of October 11th, 2024, the state believes that there is an ample amount of evidence that YSL is a criminal street gang. That evidence of that, and the reason that's so important to the court's question is once that evidence is either established or you proffer to a court and ultimately before the trial resumes is in evidence, then if they furthered that conspiracy, then it would satisfy.
So, I mean, I think there's other evidence in this case that establishes that both of these people would be co-conspirators. So I am going to let this one in.
Judge, I guess I don't understand what the other.
Well, I mean, like just for example, the focus on Clinton and him already knowing that that's important, and the person Gorilla having been the one who stamped him, things like that.
Right, but the requirement is that it be outside of those statements.
Right, right. No, right, which is what I'm asking then is, it's not just their conversation together. We already know from other things that a focus on Cleveland Avenue and a person named Gorilla are related to and important to this alleged gang. And that is outside of this conversation. And so things within this conversation.
I don't think that's.
Okay.
If I
So
can use your case.
Yes, because I would think, I need to know the answer to that.
I'm taking a look, Judge, at Williams versus State, which is 293 Georgia 750 from 2013, and talking about co-conspirator statements. The requirement is a prima facie case. The rule says prior to introduction of the statements. That case held it didn't have to be literally prior, it just had to be at some point during the trial. But it cites, furthermore, conspiracy may be shown by direct proof or by an inference deduced from acts and conduct. And the content of this statement is neither act nor conduct. The continuation, which discloses a common design to act in concert for the accomplishment of the unlawful purpose, common design or purpose may be shown by direct or circumstantial evidence. But I think by that, there has to be act or conduct, not just the content of this statement.
Your Honor, if I may.
Yeah.
So I wrote this, and so the case citations, I'm looking at my motion that was filed July 26, 2024, which is the state's response in opposition to defendant Stilwell's motion for reconsideration. This is straight from Kemp v. State, a case 5 years afterwards, and is a seminal case. You need to look at gang conspiracy cases to fully appreciate the 801D2E exception in the context of a street gang RICO.
The site, please.
And so,
What's the site?
So
Kemp?
Kemp v. State is 303 Georgia 385 392 2018. All of the cases that I'm going to be citing are in this e-filed motion on July 26 at 11:19 p.m. All that said, starting from the basics, 801D2E. 801D2E mandates that the hearsay prescriptions do not apply to a statement by a co-conspirator of a party during the course and in furtherance of the conspiracy. So going on a little further, the state, and this is straight from Kemp, Penn site 392, the state is required to show by a preponderance of the evidence that, number one, a conspiracy existed, which in this case is the YSL criminal street gang enterprise. Number two, the conspiracy included the declarant and the defendant against whom the state is offered, which the state, again, this is Blaylock, this individual he's talking about, and the 6 defendants in this trial, they all have to be a part of the same street gang
Nobody has
conspiracy.
a problem with Blaylock being considered a co-conspirator.
Yes, Your Honor.
It's this other person and how that can be established. And
So,
maybe you were getting to that, but
yes, Your Honor. And so I will find, I'm trying to find the case site on this specific, if you, court gives me one brief second.
sure.
Sorry, Mr. Atkins, the pin site, please.
Pin site was 392 for,
Thank you.
But I'm not sure it answers the question we're discussing right now. Maybe it does, I don't know.
well, Your Honor,
Mhm.
I was trying to find my understanding
Okay.
is if you had a statement, you're not restricted to the 4 corners of, you just have to prove to the court by preponderance that the person making the statement, which in this context is snake life maniac.
Right.
You can use the 4 walls, so to speak, of this Instagram thread. You could also use other evidence if the state had it. The court just has to find that snake life maniac is, to a preponderance, a member of the same criminal street gang conspiracy as Blaylock and the defendants, or the argument the state makes in terms of if you believe Blaylock's statements further the street gang, and there was some either context on Blaylock or non-hearsay purpose. That's how the state frames this specific issue of, and the state does believe that this is one of those unique circumstances where, because of exactly and specifically the way that they are communicating in these pages we just walked through, that to the 51% for lack, it's not numeric, but in preponderance, it's pretty close. This court can make a finding that based on the way that they are discussing and this other trial that I'm not going to all right now, and APD gang detectives, the individual is using, his handle itself is snake life,
Mhm.
coupled with, again, none of these are dispositive, but I believe that to a preponderance through this conversation, the court could find that this individual is a part of the same conspiracy as Blaylock and the defendants, which is the Wise criminal street gang enterprise.
I'm just out. Thing which I already mentioned, and that kind of corroboration is sufficient, which I would think it is. So, and frankly, you just also mentioned his Instagram handle, which might be enough right there. All right, so I am going to this admissible. However, Ms. Abbasi, if you come up with something that answers then please let me know and I'll reconsider the ruling.
Okay, and
All right.
I'm sorry, the inquiry would be if there's something
Outside of the conversation can be
part of the,
something like
what his name was, or
what his name was, or, you know, that he has what seems to be inside knowledge that we already know from other evidence is significant to this alleged gang.
Give me one moment to write it down so I don't bring you a bunch of irrelevant case law. Okay, all right,
Okay, thank you.
thank you.
All right, so sorry to take us down a detour, but it's fairly important, so.
I-
think it was a legitimate detour. All right.
Maybe
Matter that we should take a look at before going further, because that is literally the same
Okay.
argument and basis up through page remainder.
Okay. All right, so where should we move next?
you can do the videos, Your Honor.
All right.
And Mr. Atkins, if you can say like the last 4 of the videos that you're gonna play, so I can follow along. Thank you.
Is there a particular, Your Honor, could I have just 30 seconds with defense counsel? We can see where it makes the most sense to start. But what I classify as the bottom, but I'll give, they're titled different ways. They're not all numbered 1 through completion, but there is there's a video from 12, it's titled 12/20/2021 video, and it's 54 seconds.
Okay.
I don't have an objection to that one.
Okay.
There is another one with, it's 2/8. It's, some of these do have numbers. It has, if you can read the letters, free big as the caption. It's 15 seconds.
One more time, Mr.
All right, I
Atkins.
only see one that starts 28 videos and then underscore 1888 something or another. Is that the one?
Yes, Your Honor, that is correct.
Y'all got it?
No, which one was that? I'm sorry.
It is in 4719.
I can play it in court. If
Is there an objection?
Yes, could you play it for the court? I'm sorry.
I'm frankly, I'm not logged into Zoom. I'll just watch it on, well, it's a video matter. It's already done. Video matter.
So this will be objecting to relevance? It does. It
Okay.
says peace and blessings, which isn't a bad thing.
You want us to play or you?
Just if I can get my speakers. Ooh, that's loud. All right, what's the objection?
Relevance?
Your Honor, this is Mr. Darius Ford, Your Honor. So this shows a video with Mr. Ford, who we'll talk about further. He'll come in probably in the next couple of weeks. He was an individual who was killed right after Mr. Rayshawn Bennett was stabbed, not right after, but a few weeks after Mr. Rayshawn Bennett was stabbed in the Fulton County Jail. And we believe that, or the state's theory is that Mr. Ford and Mr. McMillan were killed as a retaliation of that stabbing. And so this shows the association with that individual. And I believe then the post, he says YSL as well. So
Okay.
establishing there.
And who's going to identify him?
Oh, I'm sorry. Who will identify Mr. Ford?
Yeah, that this is the person in the video.
Investigative Viverito.
All right. It's overruled.
And we also have a picture of him with another YSO co-defendant, Durante BB, that we entered.
You also need to hold that mic closer to you.
We
And
on.
turn it on.
I believe it's on.
Then hold it closer to you.
Okay. I'm sorry. Mr. Ford, YSL is not in the video. Mr. Ford, we believe, is a YSL member. There's also a picture of, you asked how can we identify him? We have a picture of Mr. Ford that has already been admitted with Mr. Ford and another co-conspirator, Durante BB.
Okay, Mr. Sharp.
So, Your Honor, my objection isn't whether this is Mr. Ford or not. My understanding is the state is saying Mr. Ford's an important part of this story because he is murdered in 2022. I understand this is a RICO case, but for the purposes of Mr. Ford and Mr. Ryan being linked, Mr. Ryan is in prison at the time of Mr. Ford's death, as well as the death that the state is claiming as payback for Mr. Ford's death.
Okay.
So, Mr. Ryan, and the reason I say that is because while I understand the state has established connections of Mr. Ford to other people, and I understand their argument for the relevance of that, I don't think that this case requires a link between Mr. Ford and Mr. Ryan as much. And my concern is obviously the prejudice and the spillover prejudice on all of us when the way of showing the link between Mr. Ford and Mr. Ryan, which I say has very limited probative value, but the video itself that shows that link involves Mr. Ryan waving a handgun around. So that's my concern.
So yours is a 403 objection. Response.
Yes, Your Honor. A part of our indictment, again, Your Honor, is that these individuals maintained armed individuals, ready and willing to preserve, protect, and enhance the reputation, power, and territory of the enterprise through the use of violence. That Mr. Ryan is publicly, these are public posts, toting his gun, and he is with another YL associate. Your Honor, believe that the probative value is substantially outweighed by its unfair prejudice.
All right. I'm going to overrule the 403 objection. What's next? Which is our next one that is objection. There is an objection to.
I guess the 12/25/2021, is that the next one?
And what's the objection?
Cumulative,
Cumulative?
because it's saying just Mary Brismus, changing out the,
This is a video?
is a video. But I
And-
believe the audio is just rapping in the background.
Okay,
State for that specific video will not use that video, 12/25/2021.
okay, so you're withdrawing that?
Yeah, I'm withdrawing, yes,
Okay.
Your Honor.
What's next? Do y'all know the next one you have objection to?
Sorry. I believe the last four is 8521, 29 videos. You can't see anybody that's in the vehicle. It's just a gun and a camera. And the caption on the video is a stick emoji, a star emoji. So the relevance, cumulative, foundation.
Your Honor, this, and Mr. Ryan is wearing a YSL chain. This is a public video where it has that snake, and you know that if the court can see, that is a probably 50 round drum in the magazine on the bottom of that gun. So it's a public display of both YSL and a firearm. So the state's purpose of this video is to show that which is important to one, create fear or for the game.
Got it, overruled.
They already have photos of him with guns.
Not with a gun with that kind of a attachment while wearing a YSL chain. All right, next.
The last for 7531. I guess video 31, the last four is 7005.
All right.
Cumulative, relevance.
All right.
There's the state will withdraw this specific video.
Okay. Next.
Three for 230. Your Honor, it's probably going to be the same, relevance, cumulative.
Is there something new in this video shown?
Your Honor, I was trying to confirm when the date of this post was where he says free little D, but I meant to have a note of that date, but the state will not introduce this. I asked grace from the court that if I find a date and someone the state believes is a YSL member, little D was incarcerated when Mr. Ryan made this visit, but no, the state is absent me readdress the court.
Honestly, I think even these.
Yes, Your Honor.
That it's cumulative.
Yes, Your Honor.
Next.
The next 0944 and the third. It's the same thing, cumulative, relevance.
All right, is there
Story
something
life.
new in the?
So this one, Your Honor, where it starts with 3-4 videos, in that video are all throwing up the YSL hand sign,
Okay.
which we have not discussed or introduced with going through this. So the state feels that that is unique and independent compared to what we've discussed thus far.
Could we do this one without the audio? The audio is not relevant. Is it?
No, Your Honor.
I'm asking the state.
Oh,
Thank you.
sorry. Well,
Your
not
Honor,
for the defense. I'm sorry. It's not relevant.
I believe there actually is some at the very end. I didn't transcribe these videos, so when I and I've
We know, that's just audio. All right. And let's take feedback.
You said you want to think about, I believe it's Mr. Blaylock's statement to someone else about joining the
Right.
gang. And, I'm sitting here and I don't know how that comes in. Mr. Blaylock's not a party, if that's okay. It's Kirkland, Kirkland, versus State 639. And that's a 2024 case. And it's in Division 4. And it actually cites the Kemp versus State
Okay.
case, which is what the state. And in that case, the Supreme Court makes it, and the defendant whom the statement is being offered against. And the court said that the trial court in that case gave a proper instruction limiting that statement only to the person making the statement.
With
It's a gang case. It's not, no, I don't, it's not a. rape
Okay,
case.
I think that might make a difference.
We're under, that's what they're traveling.
I'll look at it.
Okay, thank you. And the same in Kemp. Kemp has the same exact language.
I take a look at both of them.
Okay, thank you, Your Honor. Appreciate it.
And Williams. I'll look at
Judge?
all three of them. Yes.
How quickly do you need that additional case law? Simply because my internet connection is not very cooperative.
Well, I mean, over.
Okay.
Maybe you can find.
Yeah.
Are you joined to that?
Yeah.
Maybe you can just somewhere else. It doesn't seem to be great. Room or frankly, anywhere in the courthouse. Why we can't get that fixed, I don't know, but all right, see y'all back in an hour.
Thank you.
Hey, everybody, thank you so much for watching our coverage of the young awesome sponsor, Upside. So what's Upside? Upside is a free app that gets you cash back on daily essentials like gas and groceries. So when I go to pump my gas, I can use the Upside app and get cash back, real cash back. It's money that appears in your Upside app that you can transfer straight into your bank account. So once you have the Upside app, you claim an offer for whatever you're buying on Upside. You pay as usual using a debit or credit card. You follow the steps on the app and you get paid. And as you saw me just do, you can use Upside at places like Shell, Exxon, Mobil, 7-Eleven, Taco Earn. Click the link in the description to download Upside or scan the QR code on screen and use our promo code LC Live and you'll get an extra 25 cents back on every gallon on your first tank of gas. That's promo code LC Live for an extra 25 cents back on your first gallon of gas.
collection of drinks up here right now. All right, did anybody want to offer any further case law on that issue we were discussing before the lunch break?
Judge, I have been looking and looking and looking. I've got some references in federal cases to staying away from bootstrapping. As far as additional case law beyond that, I actually would, I guess, go back and do a closer reading of Kirkland versus State, the case that Mr. Steele cited. It does say in that, I guess kind of most poignantly is that the co-conspirator conversation, allegedly in that case, needed a limiting instruction to be admitted only to that declarant.
It does not say it needed a limiting instruction.
No, it doesn't say
A
that
limiting instruction was given, and so they're saying there can't have been any error when the jury was told only consider it against this one person. But I'm not sure that that answers the question of, it does not actually say, you know, a limiting instruction was needed. So, I mean, I was just looking at that same thing, and I'm not quite sure how to, that's the holding or result we ought to be taking from that.
And Your Honor, if the state may.
Yeah, and actually, and there was not an objection on that ground at the time.
Right.
So I'm not even sure that like that was the basis on which it came in. Yes, Mr. Atkins.
A key distinction is, and I was reading Kirkland over the break, is it cites Kemp, but these co-conspirator statements that the state's discussing pertain to the larger criminal street gang conspiracy. So in Kirkland, if I'm not mistaken, they are talking about a more classic criminal conspiracy to commit a crime in and of itself. So I haven't read front to back Kirkland, but that's my understanding. And so and the reason I highlight that is because when you have a criminal, the Kemp and the pregnancy of Chavers, when you're talking about the larger criminal conspiracy of the criminal street gang, if the declarant making that statement and the defendants are a part of that same gang, it's basically like the equivalent of a party opponent admission is how it is. You know, if you look at 801D2E and just read it. So limiting instructions are not appropriate if all the defendants in a trial are under the same criminal street gang. If the court finds that statement was made by a fellow gang member or co-conspirator of the larger street gang, whatever Kirkland is to make is not, it's apples and oranges for the context of this case. I would highlight for the court that the reason the state cites Kemp and Chavers is because it's talking about the larger street gang. Like, for example, and this is from Kemp v. State, 303 Georgia 385, Penn site 393.
I'm sorry, one more time. I'm trying to keep up.
303 Georgia 385, KEMP v. State. And the holding, I mean, in subsection I, it says the trial court was authorized to conclude that Watkins' statements were made. My apologies. The trial court was authorized to conclude that Watkins' statements were made in the course of a conspiracy. The first sentence after that is Kemp and Hogan's argue that Watkins' statements were not made in the course of a conspiracy because the conspiracy ended with Gray's death. But the defendants were alleged to have been part of a larger criminal conspiracy. And then it goes on to describe that. And again, the criminal street gang conspiracy is ongoing today. And so as long as the declarant making the statement and the defendant against whom it's utilized against or being, it's in furtherance of that conspiracy, which in this case, again, is the YSL criminal street gang or criminal enterprise as in count one, it applies to all. If the court deems that that statement was made by a fellow co-conspirator in that criminal street gang and furthers that street gang's purpose.
Your Honor,
Yeah.
the closest I can get, and I'm trying to go back and make sure I'm reading it, trying to compare the facts, is U.S. versus Olivia. It's a 1974 Fifth Circuit case, 497 F2D 130, pin site 132. The court is talking about that there's a lack of case law for trying to decide whether there's enough independent evidence or what constitutes. We have never stated in explicit terms that the standard to be used by a trial judge in determining the sufficiency of the evidence. I'm sorry. We have never stated in explicit terms the standard to be used by a trial judge in determining the sufficiency of the evidence other than the hearsay. We find it necessary to go through those things. In that case, what they talk about being the relevant other evidence, which in this case, it was not enough and it was vital and the conviction was reversed. The evidence used against the defendant there was his presence in a crowd where drugs were sold, telephone calls between that person and another person, that the appellant was in a beige Cadillac followed by the declarant into an adjacent parking lot shortly before the drugs, testimony of an officer that someone saw him in a parking lot, him driving away, a gun in someone else's possession. I'm trying to find something closer, but all of the, not factors, but all of the components which were analyzed whether this evidence was sufficient outside of the conversation were completely independent from that conversation itself. I'm still trying to find something closer, Judge. That's as close as I've gotten.
Okay. All right. And I don't know if it might be possible to see the record in the Kirkland case and figure out, if there was
It should be easily accessible.
a ruling that at the time of the trial that, hey, this is coming in under 801 D2E.
Judge, I may be able to sit in front of Odyssey and take a look. It was one of your colleagues here on that case.
Oh, okay.
Yes.
All right. I mean, I just sort of read, and I may be wrong on it, but that the court's sort of saying there can't have been an error because of this limiter that said don't consider it against Kirkland anyway. Sort of,
Well,
we don't even have an issue here. I don't know. I could be misreading it, but.
if the reason that instruction, well, the reason there was no error is because it wasn't used against that defendant regardless, then I guess the thrust of it is it shouldn't be used against a defendant, whether it comes in at all, whether a limiting instruction has that effect. It's not supposed to be used against the other defendant.
Yeah, but so the instruction actually was any out-of-court statement by one of the defendants on trial in this case after the alleged criminal act has ended may be considered only against the person who made the statement, and only if you find it was freely and voluntarily made or whatever, which is not relevant for our purposes. But after the alleged criminal act has ended, it's sort of, and there wasn't like a RICO charge or a gang charge or anything like that. It was just a murder. And there are these two co-defendants. And I don't know if it's saying like, because the alleged criminal act has ended, there can't have been a conspiracy anymore anyway, or
I will look at the facts. I know off the top of my head, cover up after the fact still is included, even though that will have, Judge, I'll try to get some more specific information.
Okay.
I don't want to guess and speculate.
Yeah.
I'll try and actually find
Okay.
the facts.
All right. Anyway, which is sort of a separate issue than our other issue, which you're also going to try to find something better on. But anyway, so my ruling on that will stand unless you bring me something that,
Well, I guess that ruling will stand does mean that we would need to keep going through all of Mr. Blaylock's records.
okay. And then, Mr. Steele, it sounded like your argument might have been, why don't you just restate your argument for me that you made just before you gave us that site to Kirkland?
I'm going to ask the court if it comes in for limiting instructions because, and I'm looking for proper cases for you to consider, but I believe that that specific colloquy that you read, or that's at issue, I don't know how to identify except the one where someone's saying, oh yeah, I'm in the gang and I was blessed in, or whatever the
Right.
words are. I don't see how that furthers the conspiracy, because it's just two people talking, hey, should I trust you or not trust you? I don't know why that is a furthering of the conspiracy. I think those are just talking about past acts, and they may be co-conspirators who don't know each other, or they may be gang members who don't know each other. So I don't know why that furthers it. But what I'm specifically looking for is Mr. Blaylock's not here. And my mind is that any statement by him should be his statement. I do understand that any act or statement of a co-conspirator to further conspiracy is an act against everyone, even if you join the conspiracy later.
Right.
But on this particular occasion, we don't know who one person is. We're letting in, it's like the tail is pulling the dog, because we're letting the conversation from an unknown person to say, oh yeah, this has to be gang related because of what's being said, when I don't know who that other person is talking with Mr. Blaylock. And so I think that we're so turned on this issue that I'd like the court to consider it. But I'm looking for better cases for you, that if you do let it in, it's not admissible against Mr. Williams or really anybody else here, because you have one person who's severed, or he pled. Your Honor, I think he pled.
Okay.
I apologize. Didn't he plead?
He did not.
Okay. Mr. Blaylock pled.
Anyway, that's neither here nor there.
Okay, well, he's not here.
Right.
And then we have, to me, an unknown party. If somebody knows who that is, I apologize. I don't know who that other person is. So to me, I don't see why it passes the 801 D2E test, because I don't see how, just talking about, are you in
Can't be in furtherance of the
Exactly.
conspiracy.
Exactly.
The basis of your argument.
Exactly. That's my first issue. But if it goes beyond that, then that's a bigger issue for us, I thought. That's why I wanted you to look at that case.
Okay. And I think that was the main reason that Mr. Atkins was citing the Kemp case to talk about the liberal in a gang case. There's the crimes, but then there's the further conspiracy of the gang and its continuing nature. And I read Kemp to say the Supreme Court, are very liberal on both whether something's in furtherance of the conspiracy, and there was another one that they were like, and we're also liberal on this. I don't have that one in front of me right now because I pulled up Kirkland, but Mr. Atkins, if you've got that case still up, what was the other? There were like two of the different prongs of the 801 that.
Yes, Your Honor. So
Was the other one whether it was during the concealment phase or?
no, it was
What was
during, so
Maybe I should just pull it back up.
Your Honor, give me 1 second. And something the court said related to Kemp, and this is Penn site 394. It states at this trial, there was the Gangster Disciple Street Gang.
Right.
Detectives testifies about that. It says that Watkins, who was one of the defendants, would discuss his participation in crimes with Lewis. an admitted gang member, helped establish that Watkins was also associated with the gang, which is kind of similar to Blaylock, who there's other evidence is a member of the YSL street gang, like his social media, et cetera, that this other person speak with him. That in and of itself can be used. And then they go further. They say the fact that the defendants accomplished the specific act charged, which was murder against Gordon in this case, did not necessarily end their involvement or association with the gangster disciples, nor did the criminal street gang's purposes necessarily end with those crimes. And so I think the dispositive issue is if the court deems these statements or any statements as 801D2E, there will never be a limited instruction with the fact pattern of this case. If the court doesn't deem them admissible or says they're hearsay, well, then they're out unless there's a non-hearsay purpose. But if the court, in this case, because everyone's charged in conspiracy, if the court believes that a member of that same conspiracy made a statement that furthers the conspiracy, it would be applicable to all and would never have a limiting instruction.
Yeah. I mean, right now, I think that's correct, but of course, would consider further case law. But the court is instructing in Kemp that it's a liberal standard on both whether something was statement was made in the course of a conspiracy and whether a statement was made in furtherance of a conspiracy. So, all right.
I will keep looking.
And they're kind of specifically talking about, you know, how it in the context of a gang and the cohesiveness of a gang and all of those things that the state has been arguing. And they refer to both of those as a liberal standard that that we here at the trial court level are supposed to be using. Okay.
Your Honor, over the break, defense counsel and the state, we were speaking, given the court's ruling, what the state would like to do for, I think it would be efficient if the court permits, is to, the state is looking through the remainder of the Instagram that is left
Okay.
with specifically Acts 79 through 81. And so we have whittled down some more, but the state would like to, if defense counsel and the court permits, give have a brief period of time to whittle it down further, present to the court and counsel. And if the arguments are to Ms. Abbasi's point, they're going to be similar arguments.
Right. Okay. All right. That's fine.
Judge, my only request with that is we've been repeatedly requesting the whittled down version and we get something, and Misty Williams and I spend hours going through it, every single page prepared to discuss it, and then the state says, well, we'll narrow it down some more. And we do this over and over.
Well, I think they're narrowing it down some more now because some of your objections have been granted.
Okay.
Or whatever. And so they're saying, okay, well, we understand that reasoning. So from the universe that you most recently got, it'll be smaller.
If we could get a deadline of time, just so we can plan on when that's due from the state.
And we can keep going through these now. I don't think it would,
No, I don't.
but it's probably only going to help defense counsel in terms of
That's
the
fine.
state's intending to reduce what we've
Right,
already.
exactly. Yeah.
Tuesday, Wednesday, just.
I would think it would be before. My plan is to do it tomorrow, depending on when we get out of court today.
Okay. That would be great. So
That would
get
be
it to
great.
them before Monday.
That would be wonderful.
Okay. All right. Okay. So what are we going to look at then?
We can keep going with the videos.
Okay. So we were on number 34 ending in 0944. Is there objection to that? Oh, no, that was, we dealt with that one. And that was, the state was going to see whether there was anything significant in the audio and otherwise. Do you know the answer to that yet?
Yes, Your Honor.
Okay.
We do not have to play that video with
All
audio.
right, so that'll be without audio. All right, so what is the next one that council has objection to?
Okay, that would be 7223, video number 35.
Okay,
And it'd be the same cumulative.
all right. And should I?
You want me to was that we went through a few
Uh-huh.
at the lunch break, and maybe the drawings. We just want to pull up and confirm it. That's
Okay.
one of the ones.
You like the gas station more good, huh?
So, Your Honor, there is another video that me and D. Williams were discussing that the state would be introducing for a similar purpose. And so the state would not be arguing to introduce 35
All right,
if there's
yeah,
another video that the
Okay.
state would,
All
that I
right,
noted.
so 35's not going to be offered. Next. Do you know which other ones aren't going to be offered?
Yes, Your Honor. And
Does Mr. Williams, do Mr. Williams and Ms. Abbasi know that?
we were discussing that before we resumed.
Okay,
And what may be helpful in this case is there is a specific video that I know me and defense counsel spoke about that they're objecting to that I can play next, which begins with or ends with 1797 and starts with videos _1985.
Could the state possibly just delete the videos that are currently in the Dropbox if they're not going to play them?
can y'all do that real?
I don't know if
Time
you can.
while
That would
we're
be very
in
simple,
the-
though.
I can. I'm also using this to publish for the court, but yes, I can delete. I mean, that takes.
Okay,
No
go ahead
time.
and delete. I've got the Dropbox up, so if you want to get rid of the ones we're not going to need to think about,
Yes, Your Honor.
and they hopefully will disappear in real time.
Mr. Atkins, please just let me know when to refresh the page.
You can refresh every couple seconds. I'm going to just be deleting as we're going through these for efficiency's sake. Your Honor, there's only two more videos, I believe, that we have not discussed.
Okay,
Well, in this folder, and then there is we'll go through these first, but I'll play the two we haven't discussed. The first is the video that starts videos 1985 and ends in 71797. And I can publish it for the court if the court would like.
okay. Well, no, I'm not on Zoom. So what did you say? It's 1797?
The last four, Your Honor, are 1797.
All right. I'll just play it up here.
Yes, Your Honor.
And is audio?
Yes, Your Honor.
Okay. I'm gonna have to. Might need to start that one over. Sorry.
You know, nigga, get it. Bitch, I push niggas that come up here in that block. Turn around, I'm sure you fit it. That's no cap. Pussy, boy. Yeah, that's what I'm saying.
All right. And the objection would be,
Cumulative and also relevance, because I don't know who the other people are.
and the response would be,
So, Your Honor, this, he says, you can't come on this block, and mentions 250, which is in reference to 250. And then the state views as well when he says Little Rod will basically shoot at you. He'll shoot at your fitted in front of Mr. Ryan, who throws up the YSL sign. He adopts that. He doesn't push back. And so it's a public display of don't come over here. He will shoot you. So the state is unique compared to other videos shown. The state does not believe this is cumulative. It's relevant because it's a display of do not come to this location, or violence will come to you.
all right, overruled. And then what would our last one we're looking at be?
So, Your Honor, this last one is, it ends in 568.
Okay, I see it.
4, and this is, I believe, 12 hours after the murder.
No
And so-
objection to that one.
Okay. Is this the entirety of the evidence for this?
I believe they have 6 videos on the Word document.
And Your Honor, I will have to operate those for the court because.
Okay, all right, that's fine. Let me just join the Zoom. Okay.
So, Your Honor, there's a Word document titled Ryan IG Live Stories that has 6 videos. So the state's going to be opening these. You have to open the Instagram return to play these. We're logging into the Zoom right now and pulling these up for the court. Pulling that up. Well, I'm trying to think of something else we could. I don't want to waste the court or counsel's time, and so.
All right, I'm open to suggestions. So I don't know, Ms. Hilton, is there something you could be pointing us to in the meantime? Or I don't know which, okay, it's not, have you screen shared yet? Because I don't see it.
I'm sorry, I'm sorry.
Well, is there something else we could be doing? Or are y'all both working on this, getting this pulled up?
We haven't pulled up on her. Mr. Atkins, we just told him to be almost.
Okay. Jury portion.
Yes, Your Honor.
If y'all want me to see, yeah.
So, Your Honor, this was posted on February 21st of 2019. The murder was February 20. Here. And so it's this, the state, the person he is adding is roniLikes, who we've talked about earlier. And he shows both an assault rifle and a handgun in this video. So the state wanted weapons of that type.
Okay, didn't we have something earlier that was being offered for the same reason?
Your Honor, that was a Instagram thread we did where I believe this was the one where someone was trying to buy
5 or
guns.
6,
Correct.
yeah.
And that I will find that PDF page number and not use that.
Which,
What thread was that?
Hmm?
What thread was that?
It was in the 5 October Mr. Sprinkles thread. It was when the person asked, he says, I will find it and let you know.
It was one of those about, it was the one that I said was okay about the back and forth with the firearms, but. Do we need the audio? Okay.
No.
All right.
The audio, Your Honor.
All right. Next.
No sound, Rudy gang. Around. Let's go.
His to show referencing that. Understand the court has previously admitted the photos of that, so I understand if the court views this would not want us to play this, but that's why the state intended to use this video.
Okay, so I would sustain and next. It's clearer in the first one than it is here, I think. But yeah, whatever, y'all choose. Your case.
Which one is the state choosing?
We'll make that decision.
And let them know. Okay.
Better work your move, cause I'm about to work my move. Slap with a dude. Now be stay what he do. Yeah, I'm on the block. Twist and
And Your Honor,
Go ahead.
the state was using this for the gang
Gang
hand
signs?
signs. Yes, Your Honor.
Okay, so y'all have already got that.
Understood,
You
Your
can
Honor.
Pick between the two, but only one of them.
Yes, Your Honor.
Next. Mr. Sharp, y'all seem to be having more fun.
We're just reviewing some surveillance, so we're ready when it's our turn.
Okay.
You always have one.
20 cent share block. You know, on Rudy Soul, I'm a pop. Cause I'm about to work my move. That's what I do. They look like Rudy.
And Your Honor, the state, given the court's prior ruling, and we will.
It's going to withdraw.
Yes, Your Honor. Yes, Your Honor. So I wanted to.
All right, what's the next thing we need to do?
Of some of the witnesses involved in the portion about Mr. Ryan, the state's contention or some to, again, be the ones to go through and say which parts should be out.
Okay, y'all, I asked y'all weeks ago to get together on this, and that means at some point, somebody needs to be the first one to say, well, how about this, or how about that?
And Your Honor, Ms. Abbasi and I.
You do it. You do it. Come on, y'all.
And Ms. Abbasi and I talked about this. She asked about the video. Her that there's only one particular part in Mr. Mitchell, and it's when Mr. Mitchell's stepfather is talking to him about life. And I said, I don't think that is proper. I said, if there's anything else, just let us know. If there's something specific that you know, and she has not responded back, to let us know.
And well, I could go through the ones that I have. The hard part on it is I have just timestamps. We don't have
Either
Together, all of this.
is everything for
Okay,
Mr.
well,
Ryan.
how about one person over here on the state side get together with one person over here with pick up with something else?
I'll do
All right, I don't care which one of you it is. Just one of you go work on this and the other one stay here and we'll do other things.
Here's my notes of what I think should be out.
Has this I didn't get a chance to get around to that either. I've been working hard on other things, so. All right, what's next then? Are you ready, Mr. Shard, on whatever it is that y'all were?
So, Ms. Hilton was with different body cam and videos that they sought to use.
Yeah.
And I have reviewed them, and obviously affects everyone, but these videos are involving Mr. Stillwell and Mr. Nichols, and the arrest of Mr. Stillwell and Mr. Nichols.
Mm-hmm.
I know that Mr. Harvey had indicated.
Mr. Harvey was supposed to be here today, so.
So and I'm not trying to draw the ire of the court or Mr. Harvey. I can just say discuss the matters, but I am not speaking on behalf of Mr. Harvey.
Okay, well, sorry. Who is representing Mr. Nichols' interests today?
I am, Your Honor, Lamar Gardner.
Gardner,
Gardner.
with a G?
Yes.
Okay.
Mr. Harvey is actually in federal court this morning at a funeral this
Oh.
afternoon.
What, federal court this morning and a funeral this afternoon? Is that what you said?
Yes, Your Honor.
Well, he didn't ask to be excused, which is fine as long as there's somebody here, but are you ready to proceed on these body cams?
I'm not, Your Honor.
Well, I mean, y'all may just not get the chance to do it then. Because we had plenty of advance that what today was gonna cover. All right, so let's go. Why is somebody from each table not leaving?
I was waiting. I can go out first.
I don't care which of you goes, but. All right, what link or whatever should I be looking at for this tranche?
I am going, I think I go off the discovery as a reserve, so I think Mr. Atkins could better answer. Dropbox, this stuff is in, but, just a couple things off the table.
Yeah,
The state has indicated that they plan to use surveillance video from the FedEx. Well, okay, I'll start with the BP. From the BP, which shows Mr. Drinks and other individuals shortly before the shooting on Windsor Street.
okay,
It's surveillance video. There's nothing particularly, there's nothing misleading about it. So I don't have any objection to that. It just kind of is what it is. It shows the surveillance of that store. There's also surveillance from the liquor store, which is an adjoining building to the BP. Don't have any issue with that.
okay,
There's surveillance from the FedEx building on Windsor Street. Don't have any issue with that.
are these all
And there's-
short?
They're all short, and I don't have any objection to them, and there's no audio on any of them
Okay.
either. So once we take those off the table, we have a helicopter, a video from the helicopter, APD Phoenix video. Now the video, Ms. Hilton identified as helicopter camera.ts. When I found it in my discovery, it didn't quite say that, but I'm fairly certain we're talking about the same video. It's what we've deemed the slow speed chase of the
Okay.
white Audi. Is that correct? That's the helicopter video we're talking about?
Yes, Your Honor. And to answer the, of course, an original question, if we go to the witness 53 to 100
Okay.
Dropbox, these videos are contained within certain witnesses to make easy so we all know what we're referencing. And then I thought I had copied the court, but I will forward to Ms.
And you
Person.
probably did. I just.
And I'm looking, I may not
so
have.
many emails.
I will forward to Ms. Percival now. I have sent defense counsel a chart essentially with some relevant timestamps and the
Okay.
videos. And so I'll forward that so we can kind of go along
Okay,
so you can see.
great.
So I'll forward that now.
All right, so let me.
And I don't think I sent it to the court because it was 2:00 in the evening.
Okay, so I've got 51 through whatever it is, 103 up. So you'll just have to tell me which folder within each of them.
So this specific video that Mr. Shard is speaking of should be in Sergeant Newman's folder.
Do you know the number, the folder number? I have them in here by,
He will be towards the end, and Sergeant Newman is folder 83.
okay. Oh, apparently it has to download, which might take forever. So,
I can share the video.
oh no, here it is.
Ms. Hilton.
Yes.
Okay, and is this, so there are 5 different clips?
So
in
it'll be
here?
the helicopter_camera.ts.
Dot.
It's the last.
None of them are labeled that. It's just helicopter camera.
And I'm sorry, I don't know why it says, if you go, are you in the Sergeant Newman folder?
Uh-huh.
Does it open up and say Phoenix Helicopter Officer Matt Peterson?
Hmm. Yes.
Once you
and
open
then
that folder?
Within there, there's clip 41516171 and then one that's not labeled.
Well, on mine, it says helicopter_camera.ts, so it should be
Okay,
that.
well, there's no .ts, but, I file type TS. Okay, so that's the one I need to be looking at.
Yes, ma'am.
I'm clicking and nothing is happening. There it goes. Okay.
Mr. Atkins originally sent this Dropbox link on August 30th, and then I resent it on September 12th.
Well, so far all it's doing is making me dizzy.
Oh, you were able to open it?
I'm watching it. I mean, it's helicopter view. I feel like I'm in a video game right now. Does it get to something relevant at some point?
It does. It
Okay.
begins the.
When you play it at trial, assuming that it is ruled in, can we skip the part where they're just flying above the city?
Well,
I mean,
what
they might be looking for something, but they certainly haven't found anything yet.
they're just trying to orient themselves to the location. So when you're listening, they're on the traffic.
Oh, am I supposed to
orienting
be hearing something?
Yes. There should be some audio.
Well.
Excuse me, Norman, may I step out for just a minute?
Okay.
You're okay with that, right?
Am I supposed to be hearing something?
You should be. And I can publish it so you can hear, or.
Why don't you? Because I'm not hearing anything.
And I don't know if there's I don't know if we need to watch the entire video, so I don't know what Mr. Sharp's objection is, because we might be able to get to that point.
Okay, so with that video.
Hang on, is this a 12-minute video?
It is, but it captures the
Or
entirety.
more than that? 13 minutes and 40 seconds? Okay, and what's the objection?
My objection is. I'm looking for the timestamp. I have it on a piece of paper here, but I think it's 10:05.
Okay,
The person in the helicopter says they or Shannon is armed, consider them armed and dangerous or armed and dangerous, and we don't think that is appropriate. Also, at the very end of the video, I think the state is of the belief that, I'll just say one of the two individuals threw a bag into a bush,
okay.
and there's commentary from the helicopter pilot about a bag in the bush. Now, if I understand, if the helicopter pilot saw it and he testifies that I saw someone wearing whatever throw a bag in the bush, then that's fine. But I don't think we need the commentary on the out of court commentary on top of the video. And that's at the very end.
We had a.
So what part of this do you want to show?
This is an entire chase. So it starts.
So who's chasing who?
So the police, so this video, so to orient the court, is on March 17, 2022. This is 3 days after the Drinks homicide.
Okay.
One of the gang investigators is at the Chick-fil-A on Cleveland Avenue. This car is a suspect vehicle at this point.
Okay.
And
which is the white Audi?
The white Audi is a suspect vehicle. And while at the Chick-fil-A, the investigator's getting his lunch, maybe Mr. Stillwell, they're getting their food, and that begins a low-speed, high-speed chase. When the helicopters start going, Mr. Stillwell gets out of the parking and they go on a chase. He goes up, wrong the wrong way up streets, and he eventually gets to a home where he runs into
Yeah.
a yard. He throws his phone away. We're able to subsequently apprehend that phone. They throw this bag of drugs away that's seen from the helicopter. Excuse me, they throw a book bag away that's seen from the helicopter. That book bag is subsequently recovered. It has drugs inside of the book bag. And so this is evidence of that interaction.
Okay, is there, so the Audi is at the Chick-fil-A,
Yes.
and then a law enforcement officer
An
is
under-
at the Chick-fil-A?
An undercover law enforcement officer is
Okay, and
behind.
then does that car start following?
The helicopter and other cars. We have a trooper that follows. All is
When
not-
does it start? And
it's-
when do we start seeing
the chase begins?
the Audi? This helicopter has been flying for 2 minutes and 16 seconds now.
Yes, Your Honor, because
All right, Phoenix, we got our mapping system up. We can,
if you listen to the radio, Phoenix information, here he's giving
Phoenix being the
the
helicopter
helicopter
from
along-
the outset.
from the outset. So what happens is the reason why it's
Okay.
and they are
So can we, the part before it gets to the Chick-fil-A, do we need that? Like, or,
we can start it at the Chick-fil-A because that is the
Okay.
relevant
okay.
portion and play it into.
And that's at minute what? 2-ish?
It's about probably where I am at 1 minute and 15
Call it.
seconds.
Well, actually, yeah. About a minute. It looks like maybe that's-
Yes, because focusing on finding the target vehicle and getting ready to be able